stage, Lordship.
Ah.
It's not...
Admission stage matlab, what you want?
Lordship, it was filed, and when it was called for, there was one order, last order was required. So we are filing the supplementary affidavit, Lordship. It is not admitted yet. Lordship, kindly include.
Motion में रखो, criminal motion.
Lordship, one another matter is, Lordship, extension of interim order.
उसको कल extension of interim order में रखो.
Lordship, may I permit to mention extension of interim order? 5 matters.
Huh?
5 matters. Extension of interim.
Why 5 matters?
There are extension of interim order in expiring 31st May 2023.
What is the matter about?
It is a matter about the results.
Why you are not coming with the final hearing?
We are ready, Your Lordship.
Okay, उसको रख दो, सबको रख दो, कल को extension of interim order. कल relaxation of bail. For? Huh? So, city cases में रखो. Hearing of motor accident claim cases. Extension of interim order.
My lords may permit me for extension of interim order.
Extension of interim. Yes. Huh? Call the list.
Item number 1.
For extension of the interim order is expiring on 30th.
What is the matter?
Lordship, this is an FIR 447, 406, 420, 506 and 34 of IP. Lordship, kindly comes to the FIR, Lordship. At page
Who is for the other side?
I for the state, my lord.
Yes.
Sir.
Yes.
Copy has been served. No, the grant application within time.
Lordship. Lordship, I am Nima Lama. Lordship.
What is the prayer? Washing?
Washing, Lordship.
Under section?
482, Lordship.
What is the section of FIR?
Lordship, 447, 406, 420, 506, 34. Lordship. The primary allegation against the prime petitioner is that he has acted as a broker in the transaction, but no monetary transaction whatsoever has taken place between the present petitioner and the complainant. Moreover, Lordship.
Where is the FIR?
Lordship, at page number 24.
Page 24. The application filed by only one accused.
Lordship, there are
Nima Lama.
Lordship, accused number 345, Sikhen Singh, Prahlad Singh, and Chintan Burman already quashed, Lordship. Lordship, the only role which the present petitioner has done in this matter is regarding witnessing the transaction. He was the witness in the deed.
Where is the FIR?
Lordship, at page number 24, Lordship.
Where is the allegation? Who is the complainant?
Lordship, the complainant is Chintaraman Burman.
Chintaraman Pradhan.
Chittaraman Pradhan.
Chittaraman Pradhan. One person, namely Nima Lama.
One person.
Yes, where is the charge sheet?
Lordship, charge sheet is at Lordship, charge sheet is at page number 31.
Then
Lordship, he was not at all party to this subsequent transaction as has been alleged. Lordship, moreover, comes to the supplementary affidavit filed by the present petitioner, Lordship. Lordship, in the supplementary affidavit, I have annexed the CRR application of the petitioners who allegedly have purchased the property. Lordship, kindly comes to paragraph number 7 of that. Certified copy, Lordship. Lordship will see that they have purchased this property from a chain of Sudrakanta Roy. Thereafter, Sudrakanta Roy transferred the property to Bhajendranath Roy. Bhajendranath Roy transferred in favor of Saileshwari. Saileshwari then have transferred to the petitioners of that case, who are also the accused person number 345. Lordship, the transaction has subsequent transaction. Subsequent transaction is not a transaction in which I was anyhow involved, as the same has taken place in the year 1983.
no. As per the FIR,
Lordship,
this petition, the first deed was executed, said the complainant has paid 30 lakh rupees.
paid 30 lakh rupees to the petitioner. Who was the owner, Lordship? Well, not the petitioner, Lordship, the original owner.
That's why he has paid the 30 lakhs to whom?
To the original owner, Lordship.
Who is the original owner?
Lordship, Sumit Roy.
Huh?
Sumit Roy.
Sumit Roy.
Lordship.
Correct.
Lordship.
Where is that deed?
Lordship.
Sumit Roy and the Nilima?
Lordship, that deed is not a part of.
Where's the deed?
Lordship, that is at page number 59, Lordship.
The Chittaraman sold to Sumit Roy.
Chintaraman purchased from Sumit Roy.
Huh?
Chintaraman purchased from Sumit Roy.
Chittaraman is the purchaser. Sumit Roy is the
Seller, Lordship.
seller.
Lordship, kindly
And what is and Palendranath Roy?
Lordship,
Who is he?
Lordship, he was that is the recital of the property, Lordship. He was the erstwhile owner, predecessor of the Sumit Roy.
And
Lordship,
kindly see the 62, page 62.
Lordship, it has been written as and, but it is not and, but it is recital of the. The chain has been elaborately discussed, Lordship. Lordship, kindly comes to page number 67. The only role played by the present petitioner is he was the second witness of this transaction.
67. 67.
He was the witness, Lordship. Just to create pressure, Lordship, this FIR has been made.
Okay, so
No transaction whatsoever has ever
so
taken
Sumit
place.
Roy sold the property to the complainant
Complainant.
by way of the registered deed
Registered
of
deed,
30th
Lordship.
September 2020.
Lordship, moreover, in the FIR, Lordship will see that before purchasing this property, the purchaser had already made a inquiry through his learned advocate, Lordship.
That is the problem with all of you. The court is putting a specific question, come to that.
Lordship.
What you made a defense, you made a defense subsequently if I am sending it to a trial.
Lordship, Lordship.
What is the case of the complainant? The complainant case is that the complainant has purchased the land from Sumit Roy, paid the 30 lakh rupees, and deed was registered. Subsequently, he went to the Merrick. When he returned back, he found that some other person
Person
has
has occupied
occupation
it.
of the property. Correct. This is the gist of the matter.
Lordship, Lordship.
So as per page 62, so there is no dispute with regard to the 30 lakhs rupees which she has paid, a deed was executed.
This was it.
Subsequently, on the third parties of where is the allegation that the Nilima has occupied the property or
No,
she has
Lordship,
sold?
there is no allegation, Lordship.
Yes, where then
He was only the witness to the transaction.
then what is the case now?
Lordship, my case is that I was only witness to the transaction. Hence, this FIR doesn't, the allegations as leveled against me doesn't lie at all, Lordship. Moreover, in the FIR, there is no specific allegation that I have taken any money from it. Even in charge sheet, no money
Who is appearing for the state?
For
Yes.
the state, my lord.
Yes.
These things can only be taken into consideration after going through the evidence. Otherwise,
Once, kindly see the charge sheet. See, the complainant case is that he has paid the amount. Nilima has taken the responsibility with regard to the landed property. 30 lakh he has purchased, he has paid, deed was executed. After the deed was executed, what is the role of the witness to the deed? If a third party entered it,
is challenged, my lord, then
Huh?
only the witness can come in.
and that deed is to be challenged before the appropriate court. How the cheating will come? It is not the case that he 30 lakh rupees has paid, no deed has been registered and the deed has been through the third party. After what has happened, after the execution of deed, your IU has not seized any further deed. You have a CD. Please come when you will come with the CD.
Lordship, I am traveling to Calcutta on 20.
Okay, let the matter appear in the month of December.
Lordship,
This is the I am not
Lordship,
extending.
kindly tomorrow I am ready to argue, Lordship. Kindly keeps it tomorrow. I am ready to argue, Lordship.
He has to bring the CD. The court has to see with regard to the what is the deed seized by the police subsequently, whether you are the part of the deed or not. In your charge sheet, you're not included whether the further deed.
Well, when charge sheet has been submitted, there is some privacy documents in favor
That's
of the
why the
prosecution.
court
My lord.
has to
Otherwise,
see if the subsequent the same deed,
my lord.
same land is the same property in the subsequent deed wherein this petition is the witness.
My lord,
Lordship,
only one
kindly
thing,
come-
my
that
lord.
document is
My-
there, Lordship.
A second. My lord, let it be fixed on tomorrow. I'm trying my best to bring the CD. Otherwise,
Which PS?
Lordship,
Which
the
PS?
documents you,
which PS?
Lordship, Bagdogra, please.
Leave the matter.
Bagdogra is here.
Calcutta.
Learned counsel for the petition has argued the matter at length. Counsel for learned APP in charge prays for a day's time to produce the CD. Let the matter appear tomorrow under the heading as part heard. Under the heading hearing as part heard at the top. The prosecution, the learned APP is in charge director to produce the CD tomorrow. Next.
Item number 2.
Yes.
Item number 2, Lordship, I appear for the petition, my lord. My lord, before your
Yes.
appearing under, my lord, the heading, my lord, extension of interim orders, my lord. Lord,
What is the main case? Tell me first. I will come to that subsequently with regard to the interim. What is the main?
that is what I was coming to, my lord. Although it's appearing under, my lord, extension, my lord, my request was, my lord, your lordship would kindly hear the, my lord, the main application, my lord. I'm led by Mr. Bhattacharya in this matter. My lord, lordship,
If you are ready to argue the matter on merit, then I will extend the time. Let you argue. Otherwise, I will not extend the interim order. I find from the record, you persons are enjoying the interim order, not coming for the hearing. That's why I kept it. You want to argue the matter, you argue the matter. Yes,
Lordship.
start. What is the matter? What is the matter?
yes, my lord. My lord, the matter is, my lord, I am, my lord, an accused in this, my lord, matter. And, my lord, the accusation against me, my lord, that out of 16,000 bottles of fensidyl syrup, my lord, I had, my lord, sold 5,000 to, my lord, one of the accused who's Rahul Rahman, my lord. My lord, that's the only statement, my lord, without any, my lord, transaction, my lord, without any call records, my lord. I am, in fact, my lord, not even based in India, my lord. I'm based in Dubai right now, my lord. And, my lord, it is only on the basis of, my lord, the statement of the co-accused. My lord, on several occasions, my lord, we were there, my lord, physically we were present, my lord. The matter could not be argued, my lord. If your lordship sees, my lord, in fact, my lord, there's an order which specifically records, my lord, that Mr. Ayan Bhattacharya was also physically present over there, my lord. But, my lord, they had taken sought for time. On the last occasion, also, my lord, learned DSGI's, my lord, mother had expired, so they had sought for time, my lord. After that, it was not today. The matter was there in the list, could not be taken up, my lord. So, my lord, I was humbly praying, my lord, we want to come down there, my lord, and argue this physically. My lord, Mr. Bhattacharya is, my lord,
Yes,
specific
yes.
for this. So, if your lordship,
Mr. Nakib, there is no problem. Do you argue the matter online? What is the written in the only the same thing you will argue the matter? I will take note of it. There is no necessity for physical appearance, but this court is not inclined to extend the interim order. If you have wanted to argue the matter, then I will hear the matter.
my lord, then, my lord, may I made a very
I already, on the very first day, I stated that interim order, then I will go on the merit of the matter. I find that every time.
I was
Only
aware of-
you persons are taking, kindly see when 20 January 2025, you are enjoying the interim order.
every time, my lord, we have prayed for the
Yes,
matter.
yes, argue the matter, argue the matter, argue the matter.
Lordship, I am being led by Mr.
Though the matter is fixed today for
Lordship,
extension of interim order, this court find.
Lordship, I'm praying for a not today only for a not today, my lord. Kindly keep
No,
it tomorrow.
no, tomorrow already the other matter is fixed. Tomorrow already other matter is fixed.
I'm very humbly, my lord, praying for this, my lord. I'm being led by Mr. Ayan Bhattacharya in this matter, my lord. Kindly
Maybe. Though the matter is fixed today for extension of interim order, but this court find that the petitioner has filed the instant revisional application challenging the proceedings of.
Then, my lord, I will argue the matter in that
And
case.
see-
Your lordship not
Yes,
willing-
argue.
Yes, lordship,
Argue, no problem.
yes, lordship kindly takes up, my lord, the main application, my lord. The complaint, my lord, is at page 26.
Page
26.
26. Yes.
My lord, the allegation, so far as my lord concerned, my lord, for that, my lord, come page 37, my lord.
Yes.
Yes, kindly comes to, my lord, paragraph 14.
Paragraph
14. Which is under the heading investigation against the arrested accused person Rahul Rahman and absconder, my lord, Zakir Hussain. Now, my lord,
So
the
here
case-
is who is the petitioner? Here Asif Muhammad.
I am Asif Muhammad. Correct, my lord. I am Asif Muhammad.
Yes.
Yes, kindly comes to, my lord, paragraph 14, my lord. And Lord, kindly comes to, my lord, 1, 2, 3, 4, fourth line, my lord. Fourth line from the top of paragraph 14. Well, this is about Rahul Rahman. He says that he stated that after leaving tobacco trading business of his father, he got engaged in the business of cloth. He further stated that before a few months, he came into contact of Asif, resident of Meerut, through
Yes.
one Chain Roog Vaid, alias Chain Babu, whose cloth shop is situated near to his own cloth shop at Dinhata. He further stated that Chain Roog Vaid was engaged in transferring Asif money through Hawala. Then, my lord, this work he used to get good commission. Rahul Rahman further confessed that after coming into contact of Asif, he started trafficking codeine-based cough syrup. Then, my lord, kindly turns over, my lord. That Rahul Rahman in his voluntary statement, kindly notes, my lord, Rahul Rahman in his voluntary statement confessed that he is the owner of 5,000 bottles of fentanyl cough syrup out of 16,549 from the house of Zakir Hussain, which he had purchased from Asif, son of Fasat village so and so, Meerut without bill. So he further acknowledged procuring fentanyl syrup from Asif, he used to store the fentanyl syrup at the house of Zakir Hussain, for which he gave Zakir Hussain an amount of 10,000 per month. So, the case that, my lord, who has now been granted bail, Lord, came in my contact, Lord, and of 16,549 sold 5,000 bottles. Now, the specific case why they say it was without bill, there is no transaction at all, my lord.
Who is appearing? You are appearing NCP. You are having CD. So why persons are appearing? Extension of time, but you have to go to the CD. I will record an order. The authorities are not coming with the CD, only moving the extension of interim order are satisfied.
Several times it has been how long I can keep the CD? There is the door book, the CD is also needed.
How the court is going when there is an stay? How the proceeding is going before the trial court? If there is an stay of the proceeding,
Only for this petition.
how it can be? One petitioner can proceeding can be stayed. Then how you can proceed further if the application is dismissed? And you have not filed any application for vacating the stay order, and you are ready for extension of the interim order. This is the way the authorities are working here.
Early hearing for several times.
So why you are not ready today?
Direction is needed for reducing this.
Which direction? You are the authority. You have to direct the authority to bring the CD to or argue the matter, whether the court will say what paper is to be bring before the court. You are the PP, then whether the court will direct you to produce the CD or you will direct the officer to bring the CD for guide you. I don't know. You are appearing, at present you are appearing. You are responsible for that. Yes, what is the, this is the only allegation?
Yes, my lord. So, my lord, it is only on the basis of, my lord, a voluntary statement made by a co-accused, my lord, that too in custody, who is now on bail.
So is there in bank transaction has been seized?
Nothing, my lord. Not
The amount transfer.
Now, my lord, they have also produced, my lord, the call records in details, my lord. Not a single call, my lord, with me, my lord. But I
No,
am
the court is only asking one question to you, whether there is any transaction
no.
was seized by the police. Is
No.
there in the bank account seized from the by the police? There is a transaction between the main accused and you for transferring of 10,000 per month.
No, my lord, not a single transaction. Nothing.
Most transaction was made by the Hawala.
So Hawala have you can prove.
One notebook has been seized. So there was written 6 million.
Where is that?
That is in the CD.
Learned counsel for the petitioner has argued the matter at length. Full stop. Learned counsel for the state. Learned counsel for the state. Union of India. Union of India prays for time to produce the case diary. Let the matter appear tomorrow. The Union of India director produce the case diary tomorrow.
Obliged, my lord, deeply.
Next.
Item number 3.
At 3, I appear for the petition, Amulet.
My lord, I am appealing with respect to complainant.
At 3 and 4, in both petition, Amulet, I have challenged the FIR.
My lord,
Yes.
today,
So far,
my lord,
3 is
I am
concerned.
appealing for de facto complainant. Today we will be filing the supplementary affidavit. So I'm requesting it some time. Today itself we will be filing it. So I'm requesting it may be taken a passover.
Amulet, so far,
Who
3
is
is concerned.
appearing for 3?
My lord, I am
Who is
appealing
appearing
for the
for 3?
petition. I appear for the petitioner. I am for the petitioner.
and I am for
3
de
and
facto
4, I
complainant.
appear for the petitioner.
And I appear for de facto
Yes.
complainant. My lord, I am
Now,
requesting. My lord, if I may
3,
be, we will be presenting the supplementary affidavit today. So it will be taken a passover. It's my request.
What you want to disclose by way of supplementary affidavit?
My lord, there are certain documents which we have recently obtained against the accused. So we would like to present it on the record. So I'm requesting that it may be taken at passover.
Against the accused under the criminal revision, you want to file a supplementary
My lord,
document. The court has to go by the investigation report.
My
yes,
lord,
yes.
the petitioner
Has
in
to
the
go
last
by
date
the
of hearing.
investigation report.
Yeah,
Yes.
I bow down to my lord's observation. My lord, in the last date of hearing, the petitioner has presented certain documents in their own supplementary affidavit, and we want to show that the petitioner is a real culprit. So we are requesting, my lord, that it will be taken passover. We will be presenting certain supplementary documents, and we are ready for hearing.
Who is
Army-
appearing for the state?
But I am an army
Who is
officer.
appearing for the state?
And that is exactly the problem.
What
He
is
an
the
army officer.
what is the section?
I tell you,
Section
in 3,
69 along with section 63 and 64 should have been incorporated, but it has not been incorporated. Section 69 has only been incorporated. We have made a representation against the police authorities in that regard as well.
it's my case.
It's a case where the accused has suppressed the fact of his marriage and has obtained the consent for sexual intimacy on the basis of the suppressed fact, and has then forced me into marriage. He had made a false promise of marriage, and on the pretext of that false promise of marriage, he has committed rape upon me, and he had suppressed the fact that he was already married.
Now, may I make my submission?
Yes.
The FIR clearly discloses this offense, my lord. So I'm requesting that it may be passover, if possible, my lord.
What is the offense alleged, Mr.? What is the offense alleged against you?
So far, item number 3 is concerned. This is under section 69 of BNS. And the next matter is that in 69, I was enlarged on bail. I was enlarged on anticipatory bail. On the very next day, that the de facto has made another complaint against me under SST Act. And she is a lawyer. Now, Milad, I am an army officer, Milad. Admittedly, we had relations. There is no dispute. Now, the Milad, kindly takes up the complaint at page 22 in item number 3. Milad, I have challenged this complaint. Well, kindly see the timeline at page 22. The kindly see the timeline that they have stated in their own complaint. This is very important.
Who is appearing for the state?
No, this complaint is
not having CD. Just a minute, you are not having CD.
I'm not having the CD. I have the brief, but I don't know.
So, which PS?
New Jalpaiguri.
New Jalpaiguri.
And NJP. Day after tomorrow. Learned counsel for the de facto complaint submit that. In course of the day, he will file the supplementary affidavit disclosing document. Let the supplementary affidavit file after serving the copy to the learned counsel for the petition the state. For the counsel for the state press for time to produce CD. Let the CD be produced on day after tomorrow.
I'll be expecting an advance copy.
And 20th May. 20th.
Obliged.
For the affidavit service and repeat.
Affidavit service capital. Next.
But will you extend the interim order in the meantime?
4 or 3 or 4. Come day after tomorrow. Come day after tomorrow.
Okay. As well as
3 4 same.
4 is same lad. It is the same person.
Yes. Yes. Next.
Item number 5. So she went for the revisionist. So this is the affidavit of service.
Yes.
This extension of the interim stay order. So though this is a revision, but in form of an appeal. That is the reason is that the petitioner was convicted in the trial court. Then appeal was preferred before the learned first track Sessions Court. The Sessions Court framed 6 issues and remit back to the trial court for adjudication of those points. Those points were considered, and once again he was convicted for 5 years and 10,000.
For what offense?
Wildlife law, 51.
Wildlife. 51.
51.
What is the wildlife?
Wildlife protection.
What is the?
Lordship, no, that some articles like Lordship one. Some wildlife articles like 1 second, Lordship.
Is a complaint case?
Complaint case. Now what happened, Lordship? Now, Lordship, what happened? Against that, once again the appeal was preferred, and the sentence was reduced, but and confirmed, modified.
What is the sentence?
So 3 years.
What was the original sentence?
5 years.
Magistrate?
5 years.
For
now, Lordship,
51.
Lordship.
Or 39.
She did not bring the brief even, Lordship, only the copies.
That is the problem. You persons are only interested with the interim order, not coming.
No, Lordship, the trial court record required to come because the evidences will show.
Trial court record ache ki?
No, Lordship.
Record nahi. When the interim order was granted?
Lordship, it was granted. Lastly, on Lordship, February 17, 2026. Last page, page 10.
CRN?
Lordship, CRN 3.
What is CRN 4?
This one is the present one. Application is CRN 4.
No, CRN 4. What is the CRN 4?
Extension of this order. It was extended till 30th April. We filed it prior to that.
Till 30th August.
Lordship, we filed it prior to that.
No. 23rd July 2025.
No, Lordship, 17, it was the earlier order, last is page 10, 17th February 2026.
The petition has filed the present application being granted 4 of 2026, praying for extension of interim. He submits that by an order dated 17th February 2026, the interim order was extended till 30th April 2026 or until further order. Before expiry of the interim order, the petition has filed the present application for extension of interim order, but the matter could not be taken up for hearing and it paid for extension of interim. This court finds that the petition has preferred the present revisional application being CRR number 355/2025, challenging the order of conviction passed by the London Magistrate, which was modified by the London Session Judge by awarding the sentence of 3 years.
Lordship.
Awarding sentence of 3 years instead of 5 years. This court finds that this revisional is to for hearing of the revisional application, the trial court record is necessary. Accordingly, the department is directed to call for the trial court record.
Alipur, Lordship.
Trial court record of CR case number 429 of 2006 from the Additional Chief Judicial Magistrate Alipurdwar by the next date fix. Full stop. Interim order is extended till 3rd of July 2026 or until further order, whichever is.
Deep level.
LCR has been called for. In that case, interim order is not required to be granted because once the LCR is called for, automatically there is a.
If it is not, I don't know what the department will do.
Lordship, petitioners, Lordship.
Yes, next. Grant disposed of.
My lord, to petition. My lord, there is an earlier interim order that was granted.
Yes, item number
6, my lord.
Yes.
For the petitioner, my lord.
Yes.
My lord, there was direction of filing affidavits, my lord, which has been complied to, and the matter is ready for hearing. My
Yes,
lord,
what is the matter?
My lord, this matter has been filed after, my lord, a complaint was made by the petitioner to the municipal authorities regarding the unauthorized construction of the complainant. My lord, the said order was subsequently, an order of demolition has been passed by the municipality.
Correct.
After the demolition order, my lord, as a vengeance, wreaking vengeance, they lodged a false and frivolous complaint against the petitioner.
What is the section?
My lord.
What is the section against
my lord,
you?
Sections, my lord, are page 75, my lord. 79.
No, I don't have.
My lord, they have abused the provisions of ST-SC Act also, my lord.
Yes, sir.
In this process, my lord. My lord, kindly see the page 79, the written complaint itself is speaking.
What is the section, sir?
My lord, sections are
3-1, 126.
My lord.
And what is the section?
My lord, sections 126 to 115 to 351 to BNS and 31 R and S of SC/ST Prevention of Atrocities Act. My lord, after hearing the parties, my lord, an interim order was granted by this honorable court, wherein the investigation was allowed to continue.
What are the grounds for challenging?
My lord, the entire FIR, if taken on the face.
Who is for the state?
Your Lordship, I am for the opposite party.
No. Who is for the state?
I am for the state.
CD?
CD, I'm not holding this.
Yes.
My lord. So, my lord, first.
Charge sheet filed?
My lord, no, my lord, not to our knowledge.
Huh?
No, charge sheet has been filed.
Not yet filed. August 2025.
Yes, my lord.
As per our information, the charge sheet has been filed in.
My lord, we have taken instruction
Charge sheet has been.
and with the court of the learned special court, my lord, there was no charge sheet submitted, no cognizance taken, my lord. They are just making vague submissions. If they have something to substantiate, they should produce the copy. My lord, the date of complaint itself has been contradicted by the complainant itself before various forums. My lord.
What is the grounds for challenging this proceeding?
My lord, kindly takes page number.
Lordship, intimation was so close that the charge sheet has been filed.
To whom?
The complainant.
My lord, kindly takes page 69.
Charge sheet is filed.
My lord, we have not.
You not appeared with how the court.
No,
will
my
give
lord,
the
there
charge?
is-
What the stay order?
My
What
lord,
is the-
not to
what-
take any coercive steps.
Only coercive action. Where is the order of the stay?
My lord, order dated 17th of February 2026, my lord.
17th February. Investigations are continuing. No coercive steps shall be taken against the petitioner in connection present till 31st of. So it was extended.
Yes, my lord. It was subsequently extended till end of May
Now charge
2020.
sheet is filed.
My lord.
So Mr. Which PS?
My lord, it would be Darjeeling, Siliguri police station.
Next,
My lord, in the meantime, interim order be
The-
extended, my lord.
petitioner has filed the present application praying for extension of the interim order. Learned counsel for the defective complainant submits that he has got the information that investigation has been completed and charge sheet has been filed. In view of the above, this court find that at the time of hearing of the present division application, case diary is required. Case diary is required. Full stop. The Leonard PP in charge is directed to produce the case diary on the next date fix. Full stop.
Wednesday.
No, next.
Next.
List the matter. When the circuit starts, when the circuit can open.
8 June, my lord.
8 June.
So let the matter appear on 11th June.
513, 2025.
11th
Dated
June 2026. The interim order is extended till 16th of June 2026 or until further order. whichever.
Deeply obliged.
Cran number Cran 5, you filed Cran?
No, my lord, it is subsisting, my lord.
513, 25, 6, 8,
Next.
Matter 7.
Lordship, I am for the petitioner.
Yes.
This petition is advanced against for quashing the proceeding against two sister-in-law.
What is the section?
Section is case was
498A.
initiated under section 498A,
Yes.
325, 506, 34 IPC, read with 3 and 4 DP Act. The incident as alleged in the month of January. After 8 months, the FIR was lost. No explanation has been given with regard to the delay of FIR. And next thing is that these two petitioners are living separately in their marital house. There is no chance of any sort of torture by these two petitioners. And next thing is that if we go through the FIR, at a glance it will reveal that after the marriage, the lady had been to the working place of the husband at Assam Nagaon, and thereafter had been to the Siliguri, and thereafter had been to the Tufanganj police station. And to rob these petitioners, a line has been introduced in the FIR stating that all these persons, entire family, came in the marital house and demanded money and also assaulted the de facto complainant. This is the allegation against which 9 witnesses are examined, out of which one is priest.
One is?
Priest. One is neighbor. One is chance witness. And 3 are the inmates of the house. Now, from the statement under section 161 CPC, it would reveal.
CPC?
Oh, CRPC, sorry. It would reveal that there is no question of, no element of assault. And it is tried to be projected that a demand was made. This is the contention of the inmates of the house. Now, my further submission before your lordship, kindly, I like to refer page number 24. Mother. May I read in Bengali?
Who is he? Who is he?
Mother. Mother of the victim.
No. 24. Father.
Oh, father. Yes, yes. Father. এই খবর পাওয়ার পরে গত 12/1/23 তারিখে আমার মেয়ে জামাই সঞ্জয় বর্মন, তার মা, 2 ননদ আরো কয়েকজন নিয়ে আমাদের বাড়িতে আসে, একই দাবি জানায়। আমাকে হুমকি দিয়ে 3 লক্ষ টাকা দিলে সে আমার মেয়েকে ও সন্তানকে বাড়িতে তুলবে, টাকা না হলে সে আর গ্রহণ করবে না। মা, সঞ্জয়ের মা ও বোনেরা হুমকি দিয়ে বলে যে সঞ্জয়কে আবার বিয়ে দেবে। This line is a copy paste in the statement of mother and brother. It is against the PRB rules, the PRB rules 260 আরেকটা কপি। Oh, 264, may I?
260?
64. Case diaries how to be prepared. Case diaries shall be written up. Inquiry in process and are not at the end of the day. The hour of each entry and name of the place at which written shall be given in the column on the extreme left. The hour, a note shall be made at the end of each diary to place from the hour at and means by which it is dispatched, place where investigation halts, and for night shall also be mentioned, and specification. Diary, specimen case diary is given. That each and every page has to be paginated. But nothing has been paginated. All the statements are copy-paste from the computerized manner. On such allegation, an entire statement is omnibus, and on the basis of omnibus statement, it is the tendency of the de facto complainant to rob all the members of the family.
Who are they?
They are husband, parents, and sister-in-law. I am for the sister-in-laws. In such case, it is to be intervened by your lordship. In this regard, I like to refer to judgments of the Honorable Apex Court. কোথায় গেল? Dr. Sushil Kumar, page 7, para 7 and 8. I may be permitted to read. In this case, sister-in-laws
Yes, continue.
Considered the submission advanced by the parties and upon careful perusal of the materials on record, we are of the view that the High Court fell into error in restricting the quashing the proceeding only to the sister-in-law. In this case, sister-in-laws were already quashed. But the parent-in-laws were not quashed. A comparative reading of the FIR, it reveals that allegations leveled against the sister-in-law and those against the present appellants are in all material particulars identical. FIR does not assign any specific and or overact to either appellant. There are no particular date, place, and individual acts attributed to them. The lone allegation stands separately against the present appellants is that they would quarrel. This, however, does not constitute criminal offense, cannot itself sustain cognizance of offense under section 341, 323, 498A.
Yes, next.
Next, another I like to refer para.
Yes.
Para 15, 16, 17, 19 and 22. May I, this is the authority from which I like to read in page number 10, 35. Para 35. Preeti Gupta versus Preeti Gupta another versus state of Jharkhand and another. 35. Next page. The ultimate object of justice is to find out the truth and punish the guilt and protect the innocent. To find out the truth, it is a Herculean task in majority of these complaints. The tendency of implicating husband and all his immediate relations is not uncommon. At times, even after conclusion of criminal trial, it is difficult to ascertain the real truth. The courts have to be extremely careful and cautious in dealing with these complaints and must take pragmatic realities into consideration while dealing with the matrimonial case. The allegation of harassment, I'm emphasizing, the allegation of harassment of husbands' close relations who have been living in different cities and never visited or rarely visited the place where the complaint resided would have an entirely different complexion. The allegation.
Yes, next.
Next in the.
That's all.
That's all.
Yes.
Yes. In this matter, the actual fact is that.
You tell me what is the specific allegation other than the 3 lakhs rupees demand.
The specific allegation
Yes.
is that.
Where is that? Where is your statement?
It is in the letter of complaint itself and all.
That's why that's I'm telling, letter of complaint, your case is that you have given the 4 lakh rupees at the time of marriage, subsequently marriage, you have demanded 3 lakh rupees. They have not given the 3 lakhs rupees, you have been ousted. This is a simplicity case.
And also compelled to undergo abortion. For that reason only.
Where is the abortion letter? Where is the abortion certificate?
No, that for that particular reason she fled and she was kicked out of the house and she was told.
Sir, I am telling
No,
the
no,
question. You are taking the plea of the abortion. Show me that you had to be the hospital for abortion and abortion was carried out. Where is that?
In this matter, your lordship, she was constantly forced to undergo abortion and only for this reason, and she was also threatened that you have to give 3 lakh rupees.
Correct.
Or else you do the abortion.
Correct.
And for that reason, on her objection, she was kicked out of the house. It is there in the content and 161 statement.
Correct. Correct.
And one neighbor is also there who happens to be on that particular place when this family came to the house of that family and they started to abuse the family. Now your lordship kindly sees where the child was born. The child was not born at the matrimonial house. The child was born at the parental house of the wife. And for that reason itself, she could not, and for that itself, she was demanded 3 lakh rupees more as dowry. And she was not able to enter her matrimonial house because of this constant demands. And
that's why, sir, I am telling, this is your complaint.
yes,
To where is the specific who has demanded? So sister-in-law cannot be, sister-in-law cannot be.
so it is there in the complaint itself, your lordship.
That's why, where is that?
Yes, yes, yes.
You may write anything.
Yes.
Where is the evidence? You may write anything in the complaint. Where is the evidence collected by the IO? Yes. Where is, show me.
So, your lordship, kindly sees the 161 statement, your lordship.
I have gone through.
There is, no, your lordship,
Same
the neighbor,
replica.
the neighbor, kindly comes to page number. Page number 18.
Page 18.
Page number 8.
Yes.
He happens to be a witness on that particular day.
Gauranga Shah.
Yes, your lordship.
Yes. What is the statement?
Oh, do we or not? Oh, do we, at line number 1, 2, 3, 9. ও দুই ননদ কল্যাণী বর্মন আর কৃষ্ণা বর্মনও একই ভাবে ওকে ওর গর্ভের সন্তান নষ্ট করার জন্য চাপ দিতে থাকে, তাকে তার ওপর অমানসিক নির্যাতন চালাতে থাকে। সন্তান নষ্ট করতে রাজি না হওয়ায় ওরা বর্ণালীকে শ্বশুর বাড়ি থেকে তাড়িয়ে দেয়। বর্ণালী বাপের বাড়িতে এসে আশ্রয় নেয়। এই বছর জানুয়ারি মাসে ওর একটি পুত্র সন্তান হয়। It is a specific allegation against the sister-in-laws that they, along with the other petitioners, had an active role in compelling the petitioner, in compelling the wife to undergo abortion. And she was also told that if you don't undergo abortion, then we cannot maintain you and your child, and you have to bring 3 lakh rupees. And for that reason, on her objection, she was kicked out of the house. And this is the reason she took flight at the house of her, at the parental house. Now, your lordship, the case laws that my senior colleague here, your lordship, kindly comes to the judgment, Kakashan, Kausak, and Sonam and others versus State of Bihar. Lordship, this judgment, my senior colleague referred to page number 10. However, at page number 9 itself, para 32, page number 9.
Which case? Which case? Which case you're referring?
Kakashan, Kausak, and Sonam and others. At the rate Sonam and others versus State of Bihar. Page number 9.
Page number
9. He referred to the paragraph at page number 10. I am referring to the initial paragraph, page number 9.
Yes.
32 paragraph. It is a matter of common experience that most of these complaints under section 498 IPC are filed in the heat of movement over trivial issue. Now, over here, the word mentioned is trivial issue. This is not a trivial issue. The victim has been compelled to undergo abortion, and for the love of the child, and for these kind of complaints, she was kicked out. And for the, we have to kindly seize the place of birth of the child. The child took birth at the place of parental house, not at the matrimonial house.
You are Indian. You are Indian.
Yes.
If a person married, where the birth after the marriage, if the wife is supposed to deliver the child, where the wife is to be taken to the mother's house?
No.
Whether the wife has delivered the child in the hospital, in the mother's house, whether that can be treated as a 498A.
That is consensual, your lordship.
So
here she was compelled, she was kicked out.
You are arguing time and again 2 points.
Yes, your lordship.
Compared to abortion, but there is no abortion, she has given the child.
Because
she has given, just a
yes.
minute, she has given the birth of the male child. So there is no abortion.
There was no abortion.
Correct. Now, second point, you are telling that they have forced to go to the matrimonial house. That's why in the matrimonial house, she has given the birth.
No, in the parental house. In the parental house.
Correct. Parental house, she has given the birth. So that is the customary. Where is the evidence? That's why I'm telling, okay, I will consider with regard to the statement of the independent witness.
Yes.
Correct. 498A cruelty, torture, and
506.
cruelty, torture, and 498 water. Dowry. Correct. So your main case is the dowry of 3 lakh rupees and assault. Assault, where is the evidence that he has been, there is no injury report, only CL stated that we are assaulted.
Yes.
And draw out from the house.
Yes, sir.
Second thing at 3 lakh rupees. This is a demand. These are the two things.
Consequent demand after the 4 lakh.
Correct.
Yes.
Consequence demand of the 4 lakh you are given and 3 lakhs subsequently. And you are asking that, you are telling that the independent witness has corroborated your statement. That is your case? Yes. And anything further? Yes. Anything further? Yes. Who is for the state?
My lord.
Yes. What is the matter? What? You are not having the charge sheet? He has already disclosed that. You are not given the copy.
Yes, we have already supplied copy.
Already.
Copy is it?
Copy is there. Check it. Where is the evidence? What is the evidence? Because the complaint case is that at the time of marriage, 4 lakh rupees paid. That is not the case that is the dowry. Not subsequent after the marriage, they have demanded rupees 3 lakh. They have not paid 3 lakh. They have driven out from the house. And this is the matter. Assaulted and driven out. And as per the case, because his case is that is the mother, father, and whatever it is, they have given the same statement, stereophonic statement. He is relying upon the independent witness. So how far the case and what is the allegation against the sister-in-laws?
Sister-in-laws, they came. They are not the principal accused. They say they live in the same mess or they live somewhere else?
Somewhere else.
Distance.
So that's your CD can.
My lord, CD is returning.
So when? Which PS?
Kumargram PS. Kumargram, Alipurduar.
Alipurduar. Day after tomorrow.
Yes.
Lordship, I have only a line to say. The independent witness on which my friend demands, that is not corroborating the inmates who have given this statement.
Why?
There is nothing.
Why?
In the statement of inmates, and there is a difference.
What is the difference? That's I'm asking. What is the difference?
Regarding abortion and assault, nothing has been revealed in inmates. Inmate is the first. He heard from the inmates.
Who is the inmates?
Inmates, mother, father, and brother.
They are not decided about the abortion.
No.
Okay. Learned counsel for the state and the de facto complainant has concluded their argument. Learned counsel for the state prays for time to produce CD. Let the matter appear on 20th for production of CD.
Lordship,
Yes.
extend
2020 I am disposing of, no problem.
Item number 8.
Yes, your Lordship.
My lord,
Yes.
I am the petitioner in person, HON'BLE, in the case number CR 106.
Just a minute. आपको जो किसने CD लाया ना उसको नोट करके रखना पड़ेगा. Yes. You are appearing in person.
Yes, sir. Yes, my
You are
lord.
the petitioner.
Yes, ma'am. My lord.
Accused.
Yes.
What is the section?
The case number 487.
468.
Yes.
What is the ground for quashing?
Yes,
What is the ground for quashing?
the ground for quashing is that I was arrested on 22, on 9th November. And 4 years have already passed without any charge sheet so far.
Charge sheet not filed?
No. As per the last ACGM certified report, the charge sheet was not filed.
When the FIR was initiated?
On 5th of
5th November 2022.
22.
Yes, Mr.
My lord,
Charge sheet is not filed.
the last occasion, my lord, that is the 23rd of March. Order was passed.
Yes, 23rd. Name of the opposite no stand expense from the cost order. Under to the amending cost order.
So whether the copies has been served to them, my lord.
No, that name has been deleted. No? No, only the estate is there.
2 to 6.
2 to 6. They have been deleted. They have been deleted. So only the estate. Only the estate is there.
Stayed and responded to Mr. Vikas Bansal.
Where is the respondent number 2? Vikas Bansal.
Yes.
Is the complainant.
Yes.
Service, whether service.
Have you served the?
Yes, yes.
Where is the affidavit of service?
Yes, I'm sorry.
Where is the affidavit? This is supplementary affidavit of service.
Yes.
Have you saw the copy to the?
Yes.
Vikas Bansal?
Yes, yes.
Where is that?
Yeah,
It is not served. Subsequently served. Not served.
Served, my lord.
Where is the service? Track report shows that it has been served. It has been sent to the Siliguri Delivery Center. Delivered on 29/4.
Vikas Bansal.
Office. Delivered 29/4. Yes. Delivered on 29/4. Yes. Yes, service is completed. What is this?
This is, my lord, a supplementary.
Why? For
the CRAN which I have submitted regarding the subsistence allowance. I was suspended, but actually I was not.
That in the criminal division it will there those two of us. Oh, Babu. Yes, why the charge sheet is not filed? Without the charge, how you can say the case is not going? What is the ground? Only the charge sheet is not filed.
Yeah, charge sheet is not filed, and I have been.
That is only ground.
Yeah, and I have been actually falsely.
Correct. Without the charge sheet, how the court can look into your quashing?
The case diary last time, my lord Justice Sengupta has asked for the case diary to be submitted.
If the case diary is there, then we can.
Which PS?
Fasidova.
Darjeeling district.
Next PS, Wednesday,
next circuit. So what you file here? Why CRAN?
CRAN is for extension.
Entry mode is there.
Entry mode is there.
What is the entry mode? What entry mode you got?
On the paragraph 10, the
parties shall endeavor to pay for modification action vacating. What is the entry mode? Impugn proceedings shall remain in state
6 weeks.
6 weeks.
That is on 23rd of
March.
So 6 weeks, I think it's the
4th May. It is.
4th May.
Yeah, it has ended in 4th May.
The petitioner has filed the present application being CRAN 3. What is the number? CRAN 1 of 2026, praying for extension of interim order. The petitioner also filed the affidavit of service showing that this service has been affected upon the added respondent, but none appears on behalf of the added respondent. This could find that for hearing of the present revisional application, case diary is required. Accordingly, the learned APP in charge is directed to produce the case diary on the next date fixed, list the matter on next available circuit bench. The state is directed to produce the CD on the date fixed. Interim order is extended till 18th of June 2026 or until further order which was earlier. CRAN is disposed of. Next.
This number is written on police station case number.
My lord,
Washing of FIR is
Let me see the FIR. He is not stated, he is not mentioned the FIR. Which station? Where you mentioned?
Fasidao police station.
Huh?
Fasidao police station.
in paragraph 1 it is stated.
Pasidro. Yes, it is there, the certified code.
Okay. But in the hospital it is not.
My lord, with your leave, can I submit the supplementary?
Come on that. Yeah. Yes, next.
Number 10.
10. 9? 19? 10. Yes.
On the last occasion, my lord, the lordship asked for a report regarding the money trace, criminal antecedent, and my lord CDR. And nothing has been recovered from this petitioner, my lord. And my lord, the recovery is from one Ibrahim Haq. And this accused was implicated in this case on the basis of a statement of the co-accused. My lord, kindly see the coordinate bench order. On the basis of punishing judgment, Mark 67 is not admissible. And granted anticipatory, the last circuit order. But I am Anarul. Recovery was from
Yes.
Ibrahim.
Report
This
is
is the report. And the same is the number. This person is FIR name, first of all. He is FIR name person and the
what is the section? 21C.
21C every time when break was conducted, he absconded and from his the practice certified photos of cough syrup was prohibited for sale. And there, my lord, from the report, his call details could not collect the call details because his absconding. Right.
No, but the main accused was arrested.
Yes, sir.
From his call report, there is no.
He is FIR name practice. By was to the FIR.
Correct,
He was
correct.
identified by the complainant, but he fled her.
Lord, from the statement of the
Not that on the basis of the co-active statement.
yes, kindly
He
see
is
the
apprehending that he will be arrested. The thing is that he is named in the FIR. He was identified the complaint. That's why his name was there.
kindly see the FIR, Mother. His name from the statement of the poet. Two persons are named. One Shahidul and Anarul. Can you see page 11 and 12? The FIR. Or charge sheet has submitted, Mother.
But
Criminal antecedents are there.
no, but your IO has arrested one accused person was arrested. So his phone details was there. His phone details they cannot trace out whether the call details with this accused person.
That is it.
One thing. The second thing, the main accused of being arrested, his bank account auto been there.
That's what I mentioned in the matter.
But the
Previous another report was there, my lord, and he has a criminal antecedent.
that's the electricity matter, not the NDPS. No, I am asking with regard to this court by an order dated 24th March has asked a full phone conversation. You have given the example that he is not available. That's the phone conversation, but the main accused is there.
Yes, he is arrested. Charge sheet has been
His
filed.
phone number was there. So his phone number you can be taken. And account number is also there, but your IU has not. Your IU has not.
He has no account. So
Then.
Well, you have to file the charge sheet within 180 days, my lord. So if one person is arrested, if one person is there, otherwise he will get the benefit of stare decisis.
Correct.
So that's why we have
No, that-
file a charge sheet with the prayer for us for filing supplementary charge sheet after we arrest the rest of the accused.
When the FIR was chalked out,
FIR was lodged on 13th of August
25.
And charge sheet was filed after the 6th month, that is 6th of February 20.
But I'm referring on judgment murder.
What judgment?
Identical murder.
Yes.
On identical ground murder.
Yes. What is the ground?
Well, 51 murder bottles, in this case, 51 bottles has been recovered from his statement. This petitioner was named and he was granted anticipatory bail on last circuit granted, and considering the total.
You satisfied me anticipatory bail, the NDPS anticipatory bail is applicable? Satisfied this court? If you are relying upon this judgment, then you satisfied this court for the anticipatory bail. Normally, the anticipatory bail can be granted in the NDPS case.
Well, if the murder
To satisfy this court,
There.
that's why I'm asking you to satisfy this court under the NDPS Act.
Yes.
Anticipatory bail can be granted on the regular bail.
Well, if
What is the special circumstances here?
but except statement of co-accused, nothing is there, no recovery is there, my lord, and nothing, no.
If
money
you're not
is
been
there.
arrested, how the recovery can be made?
But I was not present at the spot, but on the basis of statement of the co-accused, I was implicated. My lord, kindly see. This person also, if I am involved. Kindly see that order, my lord.
Which order?
I am referring that.
Hmm.
Kindly see, my lord. For my satisfaction.
Yes, which paragraph? You tell me.
And kindly see the next page.
Ah.
Page 2. Kindly see.
Yes, I have seen next page. Which paragraph you are relying upon, Dada?
Or kindly see the second paragraph.
You're not having the copy of the order?
Only one copy.
Good. Tufan Singh is anticipatory bail. Tufan Singh is of the anticipatory bail.
Not on the anticipatory, but not 67.
Now the facts of the cases is differs from one case to another.
But
Number one,
67 is no at
section
but
37
evidentiary
where there is
value,
a
but
par.
charge sheet was submitted after
My
filing
lord
of
has to
charge
be
sheet,
prima
but
facie satisfied
statement of
that
the- but your
he is not guilty of the
lordship
offense.
knows better than me, but after filing of charge sheet, statement of the co-accused has no value, my lord. If only the basis of this complaint has been started.
Where is the FIR?
Well, I'll see page 11, Lord.
Page 1 of the CD.
Where is your name?
And my name is page 12, my lord.
Page 12.
Ibrahim Haq.
My lord,
Anarul Mia.
Anarul Mia, my lord.
Yes. Recorded now. The petitioner has filed the present application for grant of anticipatory bail in connection with
But your lordship also granted
Sita
anticipatory
Police Station case number 189 of 2025 dated 13th August 2025 under section 21 within bracket C/29 of the Narcotic and the PS Act. NDPS Act corresponding to NDPS case number 30 of 2026 pending before the special judge, which we are. Counsel for the petition submitted, the police has registered the case on 30th of August 2025 by incorporating the name of the petitioner only on the basis of the statement made by the co-accused. He further submitted that nothing has been seized from this petitioner and nothing has been seized from, and there is no connection of this petitioner with the main accused persons. He has relied on full stop. He submitted that by an order dated 24th of March 2026, this court has called for the report from the investigating agency to ascertain with regard to the criminal and antecedent from a money trial of phone call conversations between the petitioner and the principal co-accused. He submitted that even the investigating officer has not provided any information that the petitioner is having any conversation between the principal co-accused or any money transaction has been made between the petitioner and the co-accused, or any conversation has been made between the petitioner and the co-accused. He has relied upon the judgment. He relied upon the unreported judgment unreported order passed by the coordinate bench of this court in CRM within bracket capital A 129 of 2026 within bracket Shantanu Burman versus the state of West Bengal dated 27th of April 2026 27th April 2026, wherein the coordinate bench of this court in the similar circumstances of the case has granted the bail by holding that only because of the name provided by the co-accused, the petitioner cannot be entangled in the matter. Leonard PP in charge submitted the report and the case diary and submit that as the phone as the accused is absconding and the phone could not be seized, and as such the phone conversation cannot be traced out. He further submitted that the main accused who was arrested, from whom the alleged narcotics have been seized, he is not having any bank account, and as such, the investigating officer could not be traced with regard to the bank transaction between the petitioner and the co-accused. And counsel for the petition, the state further submit that he is the named accused, and as per the FIR, and as per the case, the persons, as per the FIR, these persons have been fled away from the spot, and only one accused was arrested, and as such it is category, and as such the involvement of the petitioner is, and as such there is an involvement of the petitioner in the instant crime. The learned counsel for the respective parties peruse the materials on record and the case diary produced by the petitioner, produced by the PP and learned APP in charge. This could find that the case has been registered by the police on 13th of August 2025. As per the case, the two persons have been escaped towards the escaped by taking advantage of the bad weather, and escaped into the fatty fields by taking advantage of the bad weather. And only one person has been apprehended. And from the apprehended persons, the narcotics have been seized. It is further reveals from the FIR that the name of the petitioner has been disclosed by the co-accused. It is the specific case of the prosecution that this petitioner was also with the co-accused, but when the investigating agency and when the police authorities have tried to apprehend the persons, this petitioner have fled away by taking the advantage of the bad weather into the paddy field, due to which he could not be arrested at this spot. And since then he is absconding. Considering the above, considering the above, this court did not find any merit in the considering the above, this court did not find that the petitioner is entitled to get any anticipatory bail. Accordingly, anticipatory bail is rejected. उसमें एक as regard the judgment relied by the petitioner, this court found that the judgment is distinguishable from the instant case. As in the instant case, the petitioner was fled away from the spot, and in that case, only the co-accused has narrated the name of the petitioner. Yes, next.
11.
So, I am to the petitioner.
Yes.
Nothing has been recovered from the position of the petitioner.
Ah.
The petitioner is the husband, only because he has been entangled in the case.
Petitioner is the husband of
The principal accused.
principal accused.
Nothing has been recovered from the petitioner.
What about the principal accused?
But she the wife, my wife.
What, she has got bail?
No,
What is the seizure?
91 bottles of codeine.
So what is the material against the petitioner?
My lord, the shop, as per the seizure list is in page number 7, my lord, of the CD. As per the seizure list, it was seized from the shop of Lalita Devi Singh and this petitioner. They are husband and wife. So when the raid was conducted, this Ranjit Singh, the petitioner, he was not present.
In whose name the shop is license has been issued?
No license. It's an illegal business of procedural. No license.
What is the shop?
It's only a shop of.
Shop? What shop?
Fish shop.
Fish shop and selling cup syrup. Good. Yes.
No, I am not involved. They are.
So you don't know your wife is selling the cup syrup?
Well, the report was called for. The report is there, my lord. Several calls and the CDR.
Husband wife call Miller, husband wife Miller. But telephone digital age Miller. So lordship no.
Huh?
Digital age Miller. The call are normal Miller. It's not primitive way.
He husband wife.
Huh?
Show me your mobile. How many calls you have made to your wife? Show me from the morning. I have not made a call.
No.
He knows then the shop was allotted.
FIR, it's written shop of Ranjit Singh.
Shop
Page
of
number 3 and the FIR. 50 bottles of monogold syrup, codeine base, and triple lidine. And 41 bottles of same.
50 plastic bottles containing
50 and
50
41,
plastic bottles
my lord.
containing 100 ml monogold cough syrup containing
Codeine phosphate and
codeine
triple
phosphate syrup and one
lidine.
paper carton wrapped with
Lidine.
41 plastic bottles containing 100 ml triple biconic slip. He knows them whether this shop was allotted or as it is. He knows the shop is there.
My lord, no, my lord. Regarding the ownership of the shop, there is no such documents.
No such document.
It's a street side, my lord, on the what happened in a fish shop, my lord.
What is your profession? What is your profession?
I have not.
You are also a fish seller. Is there any evidence that he is also running the said business?
No evidence.
From the shop, who is running the business? Fish business?
Husband, Ranjit Singh.
This is the understanding.
Petitioner, my lord, he used to run the business. When the raid was conducted, he was not there. His wife faced the situation and the wife was arrested.
Petitioner has filed the present application for grant of anticipatory bail in connection with NDPS, in connection with PTN in connection with Banarhat Police Station case number 32 of 2026 dated 12/2/2026 under section 21 C/29 of the NDPS Act pending before the Learned District and Session Judge Jalpaiguri. Counsel for the petition submitted that the wife of the petitioner was arrested and the petitioner is nothing has been seized from the petitioner and the petition is no way connected with the said case. He further submitted the petition, the shop is not recorded in the name of the petitioner, but the police is, but the petitioner is apprehending that at any point of time the petitioner will be arrested by the police in the instant case. Per control under police, the learned APP in charge along with the IO present and produce the CD. Learned counsel for the state submit that the petitioner was running the business in the said shop, and at the time of raid, the petitioner was not there, but when the raid was conducted, the narcotics have been seized. Police. The counsel for the state further submitted from the investigator is revealed that the petitioner is also involved in the matter. Considering the above, this court finds that the petitioner has not made out any case for grant of anticipatory bail. Accordingly, anticipatory bail rejected. Next.
12.
The arrest sections are 21C, 27A of NDPS Act. But my name has been implicated solely on the basis of custodial interrogation of the principal accused. Nothing has been recovered from me, And my lord, the principal accused has also been granted my lord bail by my lord Justice Shai Chattopadhyay, my lord.
What is the quantity?
My lord,
65 grams of tablet. This is Yaba tablet. 50 gram is the commercial.
my lord, nothing has been recovered from me.
Yes, what the
My lord, investigation officer is present, my lord. The two accused person, though CS has been filed, there are criminal antecedent, my lord.
Who is he?
He is Sajat Ali.
Sajjad Ali. His name is
Yes, he is involved in another same matter in Yaba tablet in Manikpur. It's a case of state of Assam. Manikpur PS case number 151 of 23. And same in Sahibganj PS regarding his criminal antecedent. Another cases are pending and warrant is pending in Sahibganj PS also. Regarding
This is my lord, nothing has been recovered from me.
Where is the details?
Not
Not given the details.
My lord, we have just collected the case number on the basis of the warrant. Only the case number could have been current, my lord, but we have also asked for the details of the case from Manikpur PS. This is in Assam. Which district?
There is separate case, my lord. It has no connection, my lord.
The petitioner has filed the present application for grant of anticipatory bail in connection with Sahibganj PS case number 134 of 2025 dated 11th March 2025 under section 21C/2022 within bracket C/27 capital A of the NDPS Act pending before the Learned Sessions Judge First Court NDPS Kuch Bihar. Counsel for the petition submit that the petition is not the named FIR named accused persons. The petition name has come out only during the interrogation of the co-accused who was arrested by the police. He further submit that nothing has been seized from the present petitioner. He further submit that it is well settled now that only on the basis of the statement made by the co-accused, the petitioner cannot be entangled in the matter. Learned counsel for the Learned APP in charge has produced the CD and submit that
he is named in the FIR.
Name in the FIR. He is telling that is not the name of FIR.
Sajjad Ali. Oh, two accused persons are there. One has been discharged, but not this person.
Not
sorry,
this person.
Sorry.
It has already been enlarged on bail, my
No, okay. Learned counsel for the petition submit that investigation has also been completed and the main accused person has already been granted bail. And as such, the not purpose should be served by and as such the custodial interrogation of the petition is not required in prefer anticipatory bail. Learned APP in charge has produced the CD and submit that though the investigation has been completed and the co-accused has been granted bail. Main accused has been granted bail, but against this petitioner there are two cases of pending. It is correct.
Melody is because
Two cases similar nature are pending against the petitioner, against this petitioner. Bola? Against the petition. He further submit that the petition, he further submit that the petition is very much involved in the present matter, but the police has submitted the charge sheet because of the time period prescribed under the law. At the learned counsel for the respective parties produce the materials on record. This court find that the petitioner, this court find that as per the submission made by the state, this petition is already involved in two other cases of the similar nature. Thus the petition is not entitled to get in anticipatory bail. CR dismissed. Next. 13.
Yes. So the allegation is concerned the present petitioner going to the of his sister house. Using filthy languages. He assaulted the sister and sister's son, and also took some ornaments and some cash. My lord, as for the allegations concerned, my lord, this is a pure civil dispute, my lord, that is in pending between these family members. Well, prior to this complaint, my lord.
Who is the complainant? Who is the complainant?
Complainant is they are the family members, my lord.
That's why I'm asking, what is the relation between the petitioner and the complainant?
Cousins.
They are the cousins.
Yes, my lord. Cousins, and prior to this complaint, another complaint has been filed on 9th, my lord. I have annexed that annexation P2, and where that petitioner number 1 mother has lodged that complaint, my lord, where the de facto complainant family members assaulted these petitioners mercilessly and also threat to the dire consequences, my lord. My lord, I also annexed the treatment sheet on page 13, my lord, and 14, my lord.
You are the sole accused. How many accused? 3 accused.
Before he completes, my lord, thing is that we could not collect the injury report because the CD was called for on 23rd of April, and till today it is lying with the High Court, in the High Court in our office. The IO said that she doesn't know whether the injury report has been prepared. Though we have the bedhead tickets, my lord, medical, but we don't have the injury report. And the persons, there is a counter case, and those persons.
Come on, 21st.
One day.
Learned counsel for the petitioners, learned TP in charge submit that the IO could not able to collect the injury report of the victims. Accordingly, he pressed for time. In view of the above, the case adjourned. Let the matter appear on 21st. The investigating officer is directed to produce the injury report on the next date fix. Next.
14.
Well, that's what the allegations concerned. The complaints are going to one of the person demand of the store, my lord, where warrant took place between them and the petition and the accused person, namely Bhimajan, assaulted the complaints on my. After that, the de facto complainant along with cousin reached at the place of occurrence, and later on, this present petitioner also started place and stopping also took place between them. But as per the actual practice of the case is that the de facto complainant husband is a very politically influential person, my lord.
Who?
De facto complainant husband, my lord.
Who is the de facto complainant? Tapas Roy. Huh?
There is no relation with this present petitioner.
No, what is the name of the de facto complainant? Where is the FIR?
Page number 12, my lord.
Page number 12.
Oh, it's a case of murder. 164 statements are there. This is of the mother. He is also an eyewitness, my lord. The neighbors are there. Set case 73, 74, 75.
My lord, as for the instruction is concerned, my lord, this deceased was an habitual drinker and there are many criminal activities pending. As for the instruction.
Correct, but you are.
These present petitioners are, my lord, namely Polish Bormon and Diplom's Bormon, they came later to the place of occurrence. And the principal accused is
CDR is there. CDR reflects that at the time. At that particular time, their presence were there as per the Malad travel. It's not that after the incident they came.
Where is the
Crime declaration is also vital, Malad.
Where is the
33.
Malad, whether my name is there or not there.
30. Before the doctor.
Who is the deceased?
Son of the detective. Name, my lord.
Suranjan Talukdar. A statement, but it not direct declaration.
Huh?
A statement before the medical officer, because the father.
That's what I'm telling.
The father survived. Because as per the IOD said, the dying declaration, not dying declaration.
No, that's you told us the dying declaration that you have seen that.
I can hear it.
So what is the stage of the investigation?
Charge sheet not filed. This is a case of January 11. This year. Warrant has been issued.
No, surrender. Murder case.
Murder. Maybe a drunkard, whatever.
And any persons, how many persons were arrested?
2 persons are absconding.
How many persons have been arrested? How many persons have been arrested?
No one has been.
No one is arrested. Then?
The father and 2 sons are involved. Father and 2 sons are involved. All are absconding. This petition is for one of father and one of the sons.
Who is he? Petitioner?
Petitioner Paresh Barman is the father of.
He is the father.
Diploma is it.
Vimal Control is the principal.
The petitioner has filed the present application for grant of anticipatory bail in connection with Alipur Dwar Police Station case number 17 of 2026 dated 11th of January 2026 under section 126 within bracket 2/118 within bracket 2/109/103 within bracket 1/3/5 of 3 within bracket 5 of the BNS 2023. Full stop. Counsel for the petitioner submitted. Counsel for the petitioner submitted. The petitioners are no way connected in the present case. Full stop. Only with the connected with the petitioners have been falsely implicated in the instant case. He further submitted there. Yes, what is the case? What is your submission?
The actual quarrel took place between the defendant and someone. After that,
क्या बोला? No way connected in the present case. Implicated in the present case. Full stop. He prays for him. If the petitioner has been granted anticipatory bail, they will appear before the investigating officer and will cooperate with the investigation. APP in charge has produced the case diary and submits that since the initiation of the FIR, the petitioners are absconding and their custodial interrogation is very much required. He further submits that as per the post-mortem report, the death of the deceased was occurred due to the injury caused to the deceased. Full stop. He further submitted the investigation is at early stage of, and the case is of early stage of investigation, and if at this stage the petitions are released on bail, they will hamper or tamper with the evidence. At the land counsel for the respective parties, this could find that the investigation is at early stage and the custodial interrogation of the petitions are required. If at this stage the petition is granted anticipatory bail, there is every chance that the petition will hamper and tamper with the evidence. In view of the above, CR on consensus in dismissed.
My lord, one indulgence, my lord, only that present with the IO, my IO is also present. That line.
I is present.
CD,
And produce the CD.
my lord, because that is the order of my lord, it has to come.
Next.
15. For the petition, my lord. I am trained for day after tomorrow, my lord.
Why?
My landed senior is, my lord, out of station, my lord.
What is the matter? What is the case?
CD.
What is the matter? What is the section? EC Act.
Essential.
Yes.
Key. My lord, EC Act, recovery of 7,600 liters of kerosene stored at the house of this petitioner. One person was arrested who was found in that house. He has been granted bail after 9 days. That is on 6th of March 2026. There is the sections of 317, that is dishonest recipient, my lord. 317(4), habitual purchaser of stolen property. And 317(3), these are all of BNS, my lord. Assisting in concealment of stolen property.
Yes.
My lord, kindly, my lord, let the matter be installed, my lord.
And I think 317 is sessions. 10 years.
As per the case of the petitioner, the case adjourned, let the matter appear on 20. IO is present with the CD. Let the CD produce on the next date. Next.
16.
Yeah. Yes, what is the section? Huh?
It will be 326, 307.
307. Where is the injury report?
Injury. Oh. My lord, in this case, what happened, my lord? There was a communication gap between the injured person as well as the attending doctor. So when he was asked what happened, maybe he or someone else from that person said that it may be an accidental case. So in that case, in the bedhead ticket, this is the bedhead ticket. There is a remark that it is called RTA.
Wrote of the accident.
My lord. So that note is there. That's why now there, though after that FIR was lost, injuries are there, and head fracture. Not only that, head injuries, these are not in accidental nature, but even now the injury report.
Now, what is the FIR initiated?
FIR is
under section 1172.
Yes, my lord.
And 118.
One Suleiman was and Rajesh Das. In person as well. One Suleiman was granted and still billed by the Rajesh. I am the Rajesh Das.
And the?
I am Rajesh Das.
So why this petition has not been granted bail?
By the session judge. That order is there, my lord.
What is the personal enmity of the session judge and the Rajas?
Because the head injury scan was done, head injury with a brick was done by this petitioner. And hand fracture. So that was considered.
Where is the bed ticket?
Bed ticket is page number 27.
27.
27. Page 35 is the 161 of the victim. 161, page 35.
What is the return? What is the statement?
The statement is written that his hand was fractured, injury was done by Rajesh, this petitioner, and the scan was done, severe injury was done. And hand was also fractured. Hand fracture done by the other end.
He has been granted bail.
Because it's a hand fracture, there is no chance of
What?
7 my lord.
What is the head injury? What is the injury in the head? Whether he was admitted? How many days?
1 day.
Only 1 day. The petitioner has filed the present application for grant of anticipatory bail in connection with Sahibganj Police Station case number 244 of 2025 dated 14th May 2025 under section 117 within bracket 2/118 within bracket 2/109/3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023. Counsel for the petitioner submitted the petitioner has been falsely implicated in the present case and the petitioner is no way connected with the instant case. He further submitted that the co-accused has already been granted by the Learned Court of Session Judge. He further submitted if the bail is granted, the petitioner will apply before the investigating officer and will cooperate with the investigating agency. And IO is present along with the CD. And counsel for the and the Learned APP in charge appearing for the APP in charge submits that he is as per the statement of the injured, this petitioner has assaulted due to which the victim has sustained injury on the head, and the head, full stop. The person who have been granted who has been released on bail against him that he has only due to his assault only the fracture in the right hand on the hand was sustained. Accordingly, Learned Session Judge granted bail, but this petitioner has assaulted the victim at the head and has sustained injury. At the Learned Counsel for the respective parties peruse this case diary. This court found that though the injury, the victim has sustained injury on the head, but it is aberration, and after the 1 day in the petition, the victim has been released from the hospital. This court found that the petitioner has made out a case for grant of anticipatory bail, full stop. In the event of the error, the petition may be enlarged on bail by furnishing bond of rupees 10,000 with one surety. If on bail, the petitioner shall appear before the investigating officer once in a week until the investigation is until the final report is submitted. Final report is submitted and shall appear before the trial court on each and every date of hearing. Disposed of. Next.
17.
Yes. Served. POCSO. 376. What is the age of the victim?
Marriage the elder brother. The marriage was solemnized 17 years. There is a matrimonial dispute and allegation that assault, physically, mentally torture this is father-in-law or absence of her husband in the house tried to commit rape of her. It's from 64 allegation of
Page 354.
354, the allegation of attack against the president. On the date,
where is the FIR? Eight.
On 16 of February, husband was present here and by showing high, doctors have modesty and second. Later in the husband, all English member, the parents could live here.
Bangla language. 164.
164. The husband of the victim is a migrant labor mother. In his absence, he used to stay there. She used to stay there with the babies. 3 babies. One on the lap also. Thing is that in his absence, this petitioner used to give for illicit proposals and all, and ultimately he tried. This is allegations. Medical. This is the medical also. The married lady. This is the
You are the brother-in-law?
Husband, brother-in-law.
Husband also?
Yes, and sister-in-law.
At the time when she protested, then what happens to the family members, entire family members were against her. So that's why against her husband also.
Any persons have been arrested? Husband arrested for what offense? Page number? Bangla language? Consist.
Just gone through it. Same thing, what is the
Yes, what is regard for the further investigation?
For further investigation?
Sir, capability test needs to be done of the accused. Sir, capability test, potency test.
Potent test.
Sir.
So we have not obtained the final report from the forensic test.
No, sir. So supplementary charge sheet will be submitted, sir.
The petitioner has filed the present application of grant of anticipatory bail in connection with Sadar Women Police Station case number 32 of 2026 dated 24th of February 2026 under section 85/76 within bracket 2/64 within bracket 1/62/324 within bracket 2/351 within bracket 2/3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023. The counsel for the petition submitted. The petition is no way connected in the present case and has been falsely implicated in the present case. He further submitted the co-accused persons have been granted anticipatory bail by the Learned Court of Session Judge and no purpose will be served if the petition is taken into custody. He further submitted the petition if the anticipatory bail is granted, the petition will appear before the investigating officer and cooperate with the investigation. Investigating officer is present along with the CD. Mr. Leonard APP in charge has produced the CD and submits that the victim has categorically stated the incident in the 164 statement, wherein it is categorically mentioned that the On 16th of February 2026, the petitioner, in the absence of family members, entered the house of the victim and committed the alleged offense. Police counsel to the Indian PP in charge further submit that investigation is going on and the custodial interrogation of the petition is required. He further submitted since the inception of the case, the petitioner is absconding. Police heard the learned counsel for the parties, peruse the materials on record and the city. This could find that for the proper investigation of the instant case, the custodial investigation is required. Accordingly, anticipatory prayer for anticipatory bail is rejected. CRM is dismissed. Next. Sorry. Next.
18.
What is the case?
Case initially started on a case of rape, but they actually are married.
Married?
Not married.
Socially married? You applied for marriage. Where is the social marriage? Where is the certificate of? Yes, investigation.
Investigation, in our record, we don't have, we have not been informed about the marriage.
I can pick up.
They are presented.
Both are married and
And tomorrow then the 13B will come.
no.
Or 13-1A. The petitioner has filed the present application for grant of anticipatory bail in connection with Pundibari Police Station case number 143 of 2026 dated 25th of February 2026 under section 69/115 within bracket 2/351 within bracket 3/3 within bracket 5 of the BNS 2023. Full stop. Counsel for the petition submitted, though the victim has on the complaint of the victim, the police has initiated the said case. Now, after the registration of the case, the victim and the petitioner have married socially and have also applied before the concerned authority for registration of their marriage. Then counsel appearing for the defective victim is present and he submit that the petitioner has married the victim and residing together and already applied for registration of their marriage. Full stop. In view of the full stop. IU is present. And CD is present.
Yes.
IU is present with the CD. Full stop. Leonard APP. Leonard APP in charge of produce the CD. Consider the submission made by the counsel for the respective parties. Peruse the materials on record. This could find that though on the verbal complaint of the victim, the case has been initiated, but after the initiation of the case, the petitioner has socially married with the victim and already been applied for registration of the marriage. Thus, this court funded no purpose. Thus, this court funded the custodial interrogation of the petitioner's right not required. In the event of arrest, the petitioner shall be released on bail. On furnishing bond of ₹5,000 with one surety. Full stop. 5,000 with some surety. CRM is disposed.
19.
Yes.
117, 118, 109,
19th, PS number.
Item number 19.
19, they have given a PS case number. That is Vidhan Nagar. There is no such PS called
Bhakti Nagar.
That will be a
Bhakti Nagar.
not Bhakti Nagar.
She has mentioned Bhakti Nagar through pen.
I think it's illegible.
But in our copy, they are antecedent without the rule.
So not,
That's
CD is
why-
not present. What is the CD? Learned APP in charge submit that in the cost title, the petitioner has inadvertently mentioned the Bidhanagar police station case, but it should be a Bhakti Nagar police station case number 44 of 2026, dated 16th of January 2026. Counsel for the counsel appearing for the state, please for time to produce the CD. Case is adjourned. Let the matter appear on 21st. Next.
20. That is the law section, the 109, that is 307, 117 to 325. Now, my lord, if your lordship can take some pen to peruse the FIR, and scuffling took place regarding transaction of money between the petitioner number 2 and the de facto complainant's husband. Now, out of grudge, all the family members, including the grandfather of the petitioner number 2, is aged about 80 years.
Where the incident was occurred?
But incident occurs on 7th January 2020.
Where? Which place?
At my house. So for the allegation is concerned. Now, my grandfather-in-law, my grandfather, my grandmother, my mother, all have been implicated. My grandfather and grandmother already got the privilege of
sustained injury.
So for the allegation is concerned, they sustained injury.
What is the injury? What is the injury?
That is not.
You are not aware of that.
Not aware of that.
So who is the petitioner number 1?
Petitioner number 1 is the mother of the
mother of
petitioner number 2, against whom the allegation of.
So petitioner number 1 is the mother.
Mother.
And petitioner number 2 is the main accused.
Main accused. So for the allegation is concerned, between.
So you are telling the grandfather, grandmother, what they got the bail.
They got the privilege of bail by the session judge, considering their old age.
Anticipatory. Okay.
Now this is the whole about the allegation.
How many accused? Total how many accused persons?
4 accused persons.
4 accused.
2 are on bail. 2 are
son, mother, grandfather, grandmother.
Grandmother.
Yes.
My lord, first they were treated in Siliguri hospital. That report is here, my lord.
What is the injury?
Injury report. Simple, my lord. Simple. Regarding this accused person, victim Bimal Rai, it's simple.
How many victims are there?
Two.
The injury was on the scalp, my lord. So that is the problem.
What is the nature? What is the nature? How many days he was in hospital? Hospitalized?
All night. 24 hours. And this is the letter on in North Bengal Medical College. He was referred to North Bengal Medical College.
If we get a glimpse of the injury report, so far it is concerned, that may have come on the body of 325, that is 172. How much little understanding?
How 325 fracture? You are admitting the fracture.
No. If we assume that that is why humble submission before loss.
Only one victim.
Two victims are there.
Head injury, care of assault. Date of admission 6 January. Date of discharge
now he is running his normal life.
Victims are very poor, my lord. And
victims are very poor. That is not the ground to detain him behind.
I have stated that they're so poor, it's difficult for them to continue the treatment also. They are so poor that it's difficult for them to keep the conveyance charges for going to medical college, for following up the treatment.
My lord, one indulgence I am seeking. The treatment in the government hospital or medical college is completely free. It is not a ground that my capital interrogation is. It is not a ground, sir. I'm very sorry to say, you are a senior lawyer. It is not a ground. It is not a ground like a senior lawyer will say before you his lordship that they are poor.
Both are residing in same village.
Same bill.
So,
And maybe asked not to enter into the jurisdiction of Muktinagar police station.
so where you will reside?
I will reside at my relative's house.
164 not recorded.
These are all what happened, my lord, during this election. Most of the hours will transfer, made up of case also.
7th January, the case was initiated, sir. 7th January, the case was initiated.
No, this injury is of the one of the victim, page 43. And what about the other? Ramesh Chandra Roy and another one?
First two victims, they were before the subdivisional hospital, Siliguri. From there, one of the victims was.
So, what is the other name? One is the Ramesh Chandra.
I got in the first one, Bimal and Ramesh.
Bimal and Ramesh.
I am also telling you, sir. The dispute between distribution of Belcha, Ambat, can you see the FIR?
Show me the both the injury report. One have you seen?
Both are the
With regard-
daily.
So, what is the stage of the investigation now?
That's it, not filed.
Witness have examined. The petitioner has filed the present application for grant of anticipatory bail in connection with Jalpaiguri and in connection with Bhakti Nagar Police Station case number 18 of 2026 dated 7th of January 2026 under section 126 within bracket 2/117 within bracket 2/109 within /351 within bracket 2/3 within bracket 5 of the BNS. And counsel for the petitioner submitted the petitioners have been falsely implicated in the present case. He further submitted the accused persons have been arrested. He further submitted the petition number 1 is the mother and the petition number 2 is the son with the police stop. He further submitted that the whole family have been implicated in the present case, but due to the old age, the grandfather and grandmother have been granted anticipatory bail by the Leonard Court of Session Judge. He further submitted that none of the victims has sustained any grievous injury. Only on the basis of a simple injury, the case has been initiated, though no case has been made out for the offense under section 109. 109 of the IPC. Full stop. The IU is present along with the CD. Full stop. The PP in charge has submitted the CD and submit that the investigation is going on. Full stop. He further submitted one of the victims was initially treated at the government hospital, Siliguri District Hospital. Thereafter, he was referred to NBMCI hospital for further examination. Full stop. further examination. If further submitted, the investigation is still going on, and if at this stage the petitioners are released on bail, there is every chance that the petitioner will hamper and tamper with the evidence. But the learned counsel from the respective parties peruse the material report and the case diary. This could find that from the injury report, it is find that both the victim who sustained a simple injury, and one of the victims who sustained injury at the head was admitted in the hospital for 1 day, and thereafter he has been discharged. As per the discharge slip, the condition of the victim, the condition of the victim is normal and is stable at the time of his discharge. So considering the above, this court find that the custodial interrogation of the petitioner is not required. Accordingly, if in the event of arrest, the petitioner shall be released on bail with the satisfaction of the arresting officer for furnishing bond of rupees 5,000 with 1 surety each. Full stop. If on bail, they shall the petition number 1 shall appear before the investigating officer once in a week till the final report is submitted. CRM census. Next.
21.
No, okay. Why? What is the matter? Huh? Not today. Next.
May it 22.
please, my lords. May it please, my lords.
My
Because I'm appearing through the virtual mode.
This matter, my lord, for me, there is certain problem is that, my lord, this was after this is initial 7th of May, it started. And it's a misappropriation of 1 crore 17 lakhs. So what I feel, my lord, this may be in the next circuit, my lord.
In the meantime, my lord,
No, my lord.
may I submit, my lord?
Because
My lords, may I make out my case for the interference of this honorable court? I happen to be a pension clerk who is working in this primary council for the past 30 years, my lords. And the allegation against me is based on the fact that I am working as a DDO, my lords, dues and disbursal officer, without there being any substance to that. May I take, my lords, one moment, my lords. Plus, the primary council is created under a statute, my lords. The Primary Education Act 1973. It creates a complete framework that how everything has to be done. In that framework, my lords, there are all checks and balances to see audits and reconciliation of the accounts, including the verification. Every year it has been done, my lords. For the past 30 years, there is no allegation against me. An isolated infraction has been invoked against me without even substantiating that how I am a DDO, my lords, a dues and disbursal officer. A stray complaint by the chairman, who happens to be the primary officer of this very council. The secretary is there. There's a controller of finance is there, my lords. And the interpolation has been put against me. Plus, my lords, if I may submit, if my lords may have the complaint for a moment, which has been given on 7th, on 6th, my lords, I stand corrected, my lords. It's at page number 14 of my petition, my lords. It has been lodged by the chairman, my lords, who happens to be the whole governing factor of this very primary education under the Statutory Act, my lords, of 1973. Now, what he says, my lords, is important. Para 2, if I may go straight away to, as reported to me by the controller of, may I read, my lords?
Yes.
I'm so grateful.
Mr. Razdan, it is better let the CD come because let the CD come.
My lords, at least for the interim, they may not, my lords, arrest me till the next date, my lords.
No.
Plus, I am
Well, how
30
soon you
years
will
old.
produce a CD?
Well, I am working in 30 years for in that very council, Malaj. But till the next state, Malaj, let them come with the case diary.
There are 12 transactions. Just an instance, one example. I just show one of the transactions. This is page number 78. But the amount is, what is the payment amount? 14,000. How much it is?
14,240.
14,240. Now, my lord, goes to page number 34. He has put 9 in front of that. And it becomes 9 lakhs.
14,250.
And 240. My lord can see the words also he has written 9 lakhs in front of that letter. So this is a big scam, my lord. 1 crore 17 lakhs is about identity fixed next.
Now, this is primary my contention is, Malaj. If I may, I am sorry to interrupt in between, Malaj. My lords, may kindly have what has been said against me. 1 crore 17 lakhs, 12 isolated transactions. No date mentioned. No date. When it has happened, how it has happened, who has done it, nothing.
The amount has been transferred to the accounts. That list also we have collected, page 32. The 12 persons who have received the amount, they have withdrawn it from their ATMs.
They are the beneficiaries of the transaction, Malaj. It has not come unto me. I have nothing to do with it. I have not drawn the check. I have not taken out the amount. This amount has gone to the...
Okay. This court find that Leonard APP in charge submit that the case has been initiated only on 7th of May 2026. Full stop. The case diary is required to be produced. Accordingly, case is adjourned. Let the matter appear on 6th, 8th, circuit bench is coming on. Let the matter appear on 9th of June 2026. The state is directed to produce the case diary on the date fixed.
In the middle, some question, because anytime,
can I?
No.
Can I leave it to Malas. I leave it.
Thank you.
I'm so grateful. So deeply grateful.
23. Much obliged.
23 is my application.
Yes.
So this is an application for condonation of delay in connection with the proceeding. I have challenged the interim order of maintenance passed under section 125 CRPC. Now, Lordship, before going to the Lordship,
have you served the copy?
Lord, I'm serving.
Have you served the copy?
Lord, I'm serving it.
Lordship,
Maintenance
opposite parties I have
wife. Who is appearing?
My Lord, Mr. Chakraborty.
No, Mr. Chakraborty might be for the state. Wife also.
No, why? You stated.
Is the 125?
Indeed, your Lord.
So have you served the
My Lord, I'm serving to this.
state? You serve very well. What about the wife?
My Lord, we will serve within the due course of the
Lordship,
within the due course.
No. Lordship, wife has been served. Lordship, wife and the state both have been served.
Where is the affidavit?
Lordship, previous occasion, it was served, it was dismissed for default, subsequently restored. Now, Lordship, after restoration, this is the first time.
Correct. After restoration, have you issued? At the time restoration, they appeared. No.
The learned advocate for the state appeared.
Yes, but the wife is not appeared. So you are informed with regard to the restoration of this application.
Now, subsequently, after restoration, I have I have informed the Lordship wife for my.
So copy.
Lordship, the copy has been served. Let the notice be served only. Copy already has been served. Section 5
and the opposite party number 2. The counsel for the petitioner is directed to inform the next date of hearing to the opposite party number 2 and to file the affidavit of service on the returnable date, let the matter appear before the next circuit. Next. 24.
Lord, I am for the petitions.
Yes.
This is an application for bail in connection with appeal, madam.
Bail in connection with appeal.
Yes,
What is the appeal?
My lord, petitioner has been convicted under section 304 part 2 for 5 years and 10,000, my lord.
By the?
By the, my lord.
Which court? Magistrate tribal.
My lord, by the session judge.
302?
302, my lord. And he has been convicted under section 304 part 2.
304 part 2.
Yes,
what was the sentence?
Sentence is 5 years and 10,000. My lord, the case is that the deceased and my lord, the appellant is a uncle and nephew.
Just a minute, just a minute. Where is the order?
My lord, order is with the main application.
Where is the judgment?
My lord, no. Main application, my lord, certified copy. My lord, last 4 page.
I am of the opinion sentence of reversal for 5 years along with the fine of rupees 10,000 would meet the ends of justice. In default of payment, the convict shall undergo simple imprisonment for 3 years, 3 months.
Yes,
for the offense, what is the offense?
Offense is 302. And
no, where it is mentioned? Sentence? For which offense it is the conviction? Can you come to the inner page 6 of the judgment?
Yes, my lord.
Ordering portion.
Yes, my lord. In the view of the above, I am the opinion that the sentence of the rigorous imprisonment of 5 years.
Falling under the 304 part 2.
Yes, ma'am.
Of the IPC.
Yes.
So he has been convicted for 5 years.
Yes, ma'am.
Yes. Then, so during trial he was in custody or he was on bail?
During trial I was in custody. At present I am in a custody of 1,022 days.
No. During the...
Yes, I was in custody. I was tried in custody.
As under trial?
Yes, I was under trial.
As under trial?
Yes, ma'am.
So? So when he was arrested?
I was arrested on 27th.
Date of offense of 12th of June 2026.
Yes, madam.
And when he was arrested?
I was arrested on 27th of June, my lord.
27th of June?
Yes, ma'am.
Where it is? Where from you got? 27 June 2023?
Yes, ma'am.
Yes. So you are under custody. So how you can be released after the conviction?
May I, my lord? Place my case. My lord, the case is that the deceased and the appellant is the uncle and nephew. They both working in a cement factory. Subsequently, on the date of incident, my lord, the appellant came to the deceased and asked for 500, which he denied, and subsequently he went to the spot. Subsequently, at night, when my lord, the deceased having his dinner along with his family, at that time the appellant came with a knife and my lord put a knife to the wife of the deceased, and subsequently a scuffling took place, and my lord, the deceased have been sustained a stab injury in his abdomen. That is an allegation. My lord, the alleged incident occurred on 4th of May 2023. On 4th of May 2023. Subsequently, my lord, he had been admitted to the hospital, and my lord, victim had died on 26th of May after 19 days. My lord, at the time of alleged incident, they did not lodge any FIR. After the death of the deceased, they did not lodge any FIR. Subsequently, after 17 days, they lodged the FIR. That is the 39 delay from the date of incident. And subsequently, my lord, the case has been started. And in the deposition, if your lordship kindly look,
Malad kindly comes to PW1, Malad. The green flag first.
Yes. Who is the PW1?
PW1 is the Malad complainant being the son of the deceased.
Son of the deceased.
Yes, Malad.
He was the eyewitness.
He is the eyewitness.
Yes.
Page, Malad, the internal page 3, Malad. Point number 9.
Yes.
The
page 3, point number 9.
Point number 9, Malad. Internal page 3, Malad. Page 22 of the certificate copy.
Page 22.
22, Malad, page 20. Because Malad, there is a mismatch in the.
Yes, page 29. His
yes,
father
Malad.
and mine.
Yes, Malad.
His father and my father.
No, Malad, the prosecution opened a sealed envelope.
Which question? Question?
Malad, 9, the prosecution opens a sealed envelope in open court.
No, question number?
Question number
Serial
9.
number?
9.
Of the PW1?
Of the PW1.
Vikram Berman?
Yes, Malad.
Vikram Berman?
Yes, Malad.
Question number 9.
Question number 9.
Question number 9 is his father and my father built their respective houses on the same land.
Malad, there is a very mismatch in the
correct
portion. Malad, thereafter 1 page. Malad, deferred in the prayer of the defense. Thereafter, Malad, the cross-examination started, and at that time, point number 9. The prosecution opens a sealed envelope in open court and produces a small foldable knife. The said knife.
No. Where from you?
Malad, kindly see my portion.
Page 3 is missing here.
My lord, it is a certified copy. They
Here it is
Xerox both sides. That is why, my lord, there is a.
Obviously, sir.
Yes, copy has been served. Long back.
Not served?
Yes, I have a served, my lord.
Give the copy. Stab my father.
Yes.
Yeah, take this. That page is not here.
My lord, I have now the prosecution, the said knife which was used by the accused to stab my father. My lord, that is the allegation that a foldable knife have been used to stab his father. My lord, the same knife has never been sent to the forensic, number 1, and my lord, the IO in his cross-examination as well as in the seizure list never sees a foldable knife. They seize a 8-inch knife. Seizure list.
Yes, 5 years.
My lord, 5 years. I already 3 years. I am in custody.
He was already in custody since beginning. The petitioner has preferred the present appeal against the judgment passed by the learned session judge.
Yes, my lord.
Passed by the learned additional district and session judge, fast track court, Kuch Bihar.
Charge case initially started under
302.
Yes, charge frame under section 30.
But
the conviction can be 5 years, madam.
Now, 304 part 2.
Oh, part 2 is
part 2.
Under conviction under section 304 part 2.
304 part 2.
Oh,
that's why
my lord, that can.
And since
because there is a very lacuna. That is why, my lord, I have convicted under section 304 part 2.
Could be dated 8th May. What is the date of the judgment?
Yes, my lord.
8th August 2025.
8th
August 2025. Wherein the learned session judge, wherein the learned judge has found guilty, wherein the session judge has convicted the petitioner for the offense under section 304 part Roman 2 of the Indian Penal Code, and sentence of rigorous imprisonment within bracket RI for a period of 5 years with a fine of rupees 10,000 in default, simple imprisonment within bracket SI for a further period of 3 months. Police. Now, counsel for the petitioner submit that the alleged incident was occurred on
4th of May 2023.
Alleged incident was occurred on 4th of May 2023, but the case was initiated on 12th of June 2023, that is after the death of the deceased. He further submit that subsequently the petitioner was arrested on
Petitioner arrest 27th of June
27th of June 2023, and since the arrest the petitioner was in custody, is in correctional. He further submitted the petitioner has faced the trial as under trial prisoner and he has completed more than how many days?
1025 days, madam. Today.
More than
1025.
1025 days. Yes. 1225 days, 10025 days in the correctional home. He further submitted that he is the permanent resident of which area? He is the permanent resident of New Kuch Bihar under PS Pundibari, district Kuch Bihar, and if he is released on bail, he will communicate police from Kuch Bihar. He further submitted that there is every chance that the petition will succeed in the appeal. Police. And counsel for the state submitted though the case has been initiated against the petition for the offence under section 302 of the IPC, but after the completion of the trial, the learned trial judge has found that the petitioner has committed the offence and the learned trial judge has convicted the petitioner under 304 part 2 of the IPC, and the petitioner was all along in the custody during the trial and has already been convicted. If at this stage the petition is enlarged on bail, the petition will flee away from justice. At the learned counsel for the respective parties peruse the materials on record, this court find that the petitioner is in custody, is in correctional home for the last more than 1025 days, and the conviction is only 5 years. 5 years. Full stop. 5 years. Under such, the petitioner, this court is inclined to grant bail to the petitioner by pending the instant appeal. The petitioner shall be released on bail by furnishing bond of rupees 20,000 with 2 sureties of like amount. 1 surety must be local. Full stop. Full stop. In the event of release on bail, the petitioner shall attend the PS Pundibari once in a week and once in a week without fail. In case the petitioner violate the terms, violate the condition by not appearing before the officer in charge, PS Pundibari, the same shall be reported, Pundibari, the bail granted to the petitioner shall automatically cancel. Crime number so disposed of.
10-2-1.
Huh? Section also. Section 5. Malo? Section 5 is also there.
No, section 5 has been condemned, madam.
By which order?
By previous order, madam. Appeal has been admitted and madam, section 5 has been condemned. By Honorable Justice.
Where is the order? Here is 3 admission of hearing 25-3. By which order the appeal was admitted?
Give me a madam.
Can one is disposed of, can one is disposed of, appeal is admitted.
Yes, madam.
This is CRAN 2.
Yes.
CRAN 1. CRAN 1 is with regard to the payment.
No.
Condone the delay of preparing a memo of appeal. That is
Can
condone.
one for
Huh?
one for delay.
Huh?
Can one for condonation of delay.
Condone.
Yes,
And
madam.
CAN 2?
Can 2 is the for bail application.
What is the CAN 3?
I did not file can 3, madam.
The CAN 3 is there. No, CRA 3. Where is the CAN 2? CAN 1. CAN 2 disposal.
Good.
The paper book direction is there.
Yes, madam. Last question.
Ah. There's no order for paper book.
Less than
The department is directed to prepare the paper, the requisite number of paper book within 8 weeks. 8 weeks, and to place before this court after completion, after the preparation of the.
Wait for next week. Or can I get back the certificate copy?
Yes, take that. Next.
25.
Who is for the 25? Not today.
26. I'm for the.
Yes.
Your lordship had taken up this appeal on last day, lordship.
Huh?
This is a MSCC appeal. This is that matter for
None appears on behalf of the parties. Let the matter appear before the next available circuit bench.
This is the old order.
August, June, February. Yes. Who is for the other side? Have you served?
Yes, lordship.
Where is the affidavit of service?
Lordship, paper book I have served, lordship. This is the receipt.
To whom?
To the advocate of the insurance company. The last occasion, the insurance company appeared, lordship. This is that matter. They had notional benefit.
Where is the last order? This court has taken the matter?
Yes, lordship. Last week, your lordship had taken up this matter.
By which date? On which date? কি হচ্ছে রে ওটা কোথায় which date the matter was taken up?
Not sure.
लगाया नहीं होगा ना तुम्हारा गुरु
Lordship, on 14th and 15th, the matter was taken up, but no order was passed.
No order was passed.
Or 14th and 15th.
Yes, next. Yes.
Lordship, this is that matter where notional income of the petitioner was of the appellant's son was taken up as 5,000 rupees.
Where is that?
There is the judgment, Lordship.
Page 59.
Page 39.
Monthly income. Monthly income 5,000.
Yes.
Where is your evidence? What you are doing?
Lordship, he was an unskilled labor. He was working as a daily labor in the agricultural
Who is
field.
the complainant? Who is the
Complainant
claimant?
is the mother.
Claimant is the mother.
Mother, Lordship.
He was unmarried.
Unmarried. 20 years old son, unmarried.
Where is the evidence of the mother? He was working.
Lordship.
Where is the evidence of mother?
Page 15 onwards.
Huh?
Page 15 onwards.
1-5.
1-5.
I say that on the date of action, my son was working at the cultivation field for cultivation of crops at Gumrapara PS Gudavali. At that time, one tractor came and driven the operator. Suddenly, the wheel of the tractor got struck mud and so in whose field he was working?
He was working in another person's field, a tractor of the owner of the field. It fell down on the.
Whose field it was? It was his field or?
No, not his field. Lordship, the owner of the tractor.
Where it is?
Yes. Opposite party number 1, Mokleshwar Rahman.
Where it is? Where is your case?
Lordship.
Where is the complaint?
Complaint application starts from page 1, Lordship.
Where is the annexer? MSCT case, where is the annexer A? Where you have narrated the incident? You're not disclosing annexer A, but you're giving the facts of the matter. In the MSCT cases.
With the application, there was
on 7th February, so and so. Was working at the cultivation field. Whose cultivation field?
The field belongs to the driver of the tractor, Mokleshwar, opposite party number 1.
Where it is mentioned? Not mentioned. Where is your memo of appeal?
Lordship, it is from page 1. Starts from page
Memo of
1.
appeal.
This is the application, Lordship.
Memo of appeal of this.
Memo of appeal, Lordship.
Where is that?
Page 48, Lordship.
Huh?
Page 48.
48.
48.
48.
48.
40.
48, Lordship.
Yes.
Lordship, Mr. Parthovomit is appearing here of the insurance company, Lordship.
He's
facing some personal difficulty, Lordship.
What is the personal difficulties?
He has just
What is the personal difficulty?
kindly takes up tomorrow, Lordship.
What is the minimum wage nowadays?
Lordship, nowadays in West Bengal, the
383.
minimum wages for unskilled labor is 375 per day.
375 or 386? Check. Bring the notification. Come tomorrow, bring the notification.
Lordship.
As per the prayer made by the opposite party, cases adjourned, let the matter appear tomorrow. Next. 27. Yes.
Milord, on the last occasion, your lordship, this was a new motion matter. Your lordship directed me to serve.
Yes.
Milord, upon the police as well as Milord, the private respondent. Private respondent is served, but police is not showing served in my track report.
Who is appearing? Kalchini police station. Mr. You are appearing? Serve the copy.
Sir, Milord, I'll only pray, Milord, this was new motion matter. Milord, consider this matter also. There was an MOU, Milord, I am protected by order of the civil court. I was running the tea estate, and subsequently, my lord, this FIR was filed saying I have committed theft of tea leaves, falsification of accounts of the garden, everything. At the first blush, my lord, this FIR is not sustainable.
Where is the FIR?
My lord, kindly takes, my lord, it's a very quite longish, my lord. The certified copy, if your lordship kindly takes. The certified copy, my lord, which is there at the end of the application. It was registered on 10th April 2026 and I am protected by an order of the civil court, my lord, from February 2026. Civil court of 139, my lord, is the order of the civil court.
So where is the FIR?
My lord, the certified copy, my lord.
Acha, that one, na?
Yes, yes. Well, the order of the civil court is at page 139. Prior order, much prior. Completely, my lord, an afterthought to harass me, and completely a civil dispute.
Who are the party in the civil suit?
My lord, the person
who has filed the suit? You?
I have filed the suit.
Who is the petitioner?
My lord, I am the petitioner.
Mukesh Agrawal.
Correct. My lord, would see the plaint, my lord, it is at page 129.
Just a minute.
And my lord,
Mukesh Agrawal, yes.
Yes,
And,
129.
who is the complainant?
De facto complainant is the defendant number 1 in the suit.
Defendant number 1?
Yes.
Partha Basu.
Correct. My lord, would see at the last page of the FIR.
Yes. Yes. The petitioner has filed the present application praying for present application under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for quashing of the FIR being Kalchini police station case number 39 dated 10th of April 2026 under section 3 within bracket 5/30/306/307/316 within bracket 5/336 within bracket 3/344/351 within bracket 3 and 61 within bracket 2 of the BNS 2023 pending before the London Court of Chief Judicial Magistrate Alipur Dwar being GR case number 724 of 2026. The counsel for the petitioner submitted there is a civil dispute between the petitioner and the complainant, and the petitioner already initiated a civil suit being titled suit number 5 of 2026 before the Leonard Court of Civil Justice Senior Division in Alipur Dwar. In this case, the petitioner has also obtained an interim order wherein the Leonard Civil Judge Senior Division directed the parties to maintain status quo with regard to the nature, character, title, and possession of the suit property. And the interim order is still continuing. After filing of the civil suit and obtaining the interim order dated
page 139,
interim order dated 13th of February 2026, the complainant has filed, complainant who is the defendant number 1 in the suit has filed a false complaint before the police authority on 21st of March 2026 on the basis of which the present case has been initiated.
It was received on 10th of April.
Yes.
It is dated 21st March, but it was received in the
PS. Received by the police authority on 10th of April 2026. Counsel for the petitioner submitted there is a civil dispute between the parties on only to put pressure upon the petitioner in the civil suit, the the complainant has made a false complaint against the petitioner. On the basis of which the police has initiated the criminal proceeding against the petitioner. But the petitioner, this is court find that the petitioner has made out an arguable case which is to be decided only after hearing the state as well as the respondent opposite party number 2. Opposite party number 2. In view of the above, the petition directed to sub the copy to the state as well as the opposite party number 2 and to file the affidavit of service on the next date fixed. In the meantime, the proceeding of GR case number GR case number
724 of
2026 coming before the Senate Chief Justice Adipur Dwar is stayed for a period of 6 weeks from date.
Grateful.
Lordship, before Lordship rises, I would Lordship, upon compelling circumstances, I'm mentioning this matter from principal bench. Lordship, upon may I be permitted, Lordship?
Yes.
Lordship, this matter relates to the child, my lord. Lordship has dealt it with extensively. On the last occasion, petitioners were informed that the police officers of the Manikala police station is investigating the case against the petitioner. It has already been submitted. Now, my lord, this is a very shocking thing that after your lordship ordered that the child must be returned and the adoptive parents are being added as the respondent. My lord, now the police officers shockingly started the investigation of the matter which has already been closed and FRT has been given. My lord,
Against
on
whom
the
the FIR?
against the
which?
petitioner,
Against
the
whom the
mother.
FIR? So mention
Lordship-
before the regular court, because mention before the court having the interim, having the determined. Now I cannot take the matter here.
Yes, Lordship, I can understand, Lordship. I'm just intimating your Lordship so that if your Lordship can pass any order relating, if your Lordship.
I cannot.
As your Lordship
Sitting,
has dealt with.
sitting in the Jalpaiguri, I cannot take the matter of the circuit bench because already there is a determination to the other court. You mentioned before the other court who is having the determination of my court. Please mention that. Then we'll see to that. Okay. Okay. Yes.
Item number 29.
And for the petitioner.
Yes.
May I, my lord?
Hmm.
My lord, the petitioner is the wife of the respondent number 1.
Petitioner is the
wife of the respondent number 1.
Ah.
And she has 2 children. Both are minor girls. And having suffered continuous domestic violence and harassment, my lord, she preferred.
Who is the opposite party number 1?
Opposite party number 1 is the husband.
Husband. And 2?
2 is the mother-in-law.
Mother-in-law.
Father-in-law expired during the proceeding, so I did not make him a party. My lord, subsequently, she filed an application under Section 12 of the Domestic Violence Act with an application for interim relief, my lord. The interim maintenance was granted, but the custody of the minor daughters were refused, the interim stage. It was refused. However, there is no statutory bar. My lord, being aggrieved by that order, she preferred an appeal under Section 29 of the Act before the learned session. In the appeal, the maintenance amount was enhanced. I am not here for the maintenance amount. Maintenance amount is satisfactory for the lady. But this relief of the custody of the children, one is a 9-year-old girl, my lord, and another is 7-year-old girl. So custody was denied, though there was no such modification in the appeal also, my lord. So being aggrieved by the order, I have preferred this revisional application before your lordship.
I have instructions, Lord, to appear for the husband. Let a copy be served upon me. I can come back.
Lord, I will. No, we
can do it tomorrow also, not difficult. Lord, I can come back tomorrow also, no problem. I just need a copy of that.
What do you want?
Next circuit.
Next circuit.
Next circuit. Admission and the next circuit.
Admission, then I have to hear.
Yes, that's what.
Directly can't be. If you want, then I will directly serve the copy and I will place it before the next circuit.
Well, right now I'm not ready with the copy. I can serve him the copy by the day, by this in course of the day.
It is directed to serve the copy to the opposite parties. And to file the affidavit of service on the next date fixed, list the matter before the next circuit bench. Next.
30. Copy is ready.
Praying for a short Passover.
Why?
As senior counsel, he is collecting few documents regarding this matter.
Collecting the document. Within
Yes.
short period, you will come with
No,
the
till now I
document.
have not received. He is collecting it.
What is
So-
the matter? What is the
So
matter?
Sir, praying for a short Passover.
Passover.
31. 31 is another accused. Pass, short pass. Another
Same
accused.
matter?
Same matter, Manoj. 32. Item number 32.
Item number 30 and 31.
Yes.
Lordship, 30 and 31.
30 and 31 Passover.
Yes, yes.
Let first 32.
Lordship.
Who is for the 32? Okay, Passover. Call the 30.
Item number 30.
Yes.
Lordship, this application has been filed. This is a Lordship council brief just now I have received. From the I find that the quashing of a charge sheet, which was filed for Lordship, there are certain sections 74 BNS, that is 354, 354B, 354D, 346, 376, 511, 351, 120B.
Yes.
Now, the fact of the FIR, Lordship is taking 31st, na?
Yes, 30.
30, this one, okay. Lordship kindly sees the FIR in page 17. 18 is the written complaint.
FIR is in Bangalore language? Or English?
No, Lordship, it is a typed because the petitioner happens to be, sadly happens to be a practicing advocate. So it is a well drafted FIR. The debate of Drafted from the FIR, is well drafted FIR, and I admit that it is a very bad case. Now, Lord, it kindly comes to para 2 of the written complaint. Last line, she boarded the vehicle at about 7:55 p.m. Para 2, last line. And kindly comes up the page, para 6, first line. He finally, at about 9 p.m., he chauffeured to stop the vehicle near Port Siliguri.
Yes. Yes.
Now, when it comes to page 27. 27. There is a seizure list of the CCTV which was been seized by the police.
Page 20. Page
27. What is it? This is the list dated 16/12/2026.
Yes.
And you see what all the article says. One pen drive containing CCTV footage of victim getting out of the car at around 16:47 57 and walking past the road after getting out of the car at about 16:59 hours at Portmore, opposite such and such, such and such, such and such.
Yes.
So it was on at 5 around 5. That is 4:59. And what if the CCTV footage will see will show that after getting out of the car, her body language is positive and nothing happened inside the car. Now, Worship, why is so? No. She declined for medical in writing stating that nothing happened. Worship will find it in the charge sheet. Kindly comes to the charge sheet. Last document, certificate copy, Worship.
Last document.
Last document, certificate copy. First page. This has been
Yes.
So it kindly comes to the last page of the charge sheet, second line.
Yes.
Second line. May I read, Lordship? During investigation, I informed the complainant cum victim lady to proceed toward Jalpaiguri DC hospital.
Where from? Your family reading.
Lordship, second line. Last page of the FIR.
FIR?
Charge sheet, Lordship.
Last page. During investigation, prima facie case. During investigation, served the
I
raid.
examined the complaint.
Yes, I examined the complainant.
Then, Lordship, second line. During investigation, I asked the victim to let it to proceed towards Jalpaiguri DC hospital, but she refused to move to hospital. So I served notice, submitting in writing. She does not want to proceed to Jalpaiguri as she was just touched inappropriately. In spite of reason, no parental.
Yes. Then
Now my junior brother who has filed the case just now did not incorporate these important documents. The petitioner here have two. One is the driver, another is the senior manager of a bank. Now, Lordship, the senior of the defector complainant, who is also an advocate, was empaneled with my bank. Now, what happened? Lordship knows how the banking operation works for the lawyers. That they give report regarding the property upon which the loan is taken. He has fraudulently changed the character of a land and gave the report, basically upon which the senior of this petitioner, this defector complainant. He mentioned in his report that the land belongs to Bastu, but subsequently it was found that it was not Bastu. So the Lordship knows that better than any of us, that the amount of loan and other things depend upon that investigation report. So the senior was cautioned by the bank on very day, that is on 10th December, it was deadline was given to rectify the sale, and he challenged that I will see to the sale. And on the very day, this complaint has been lodged. Now kindly appreciate, Lordship, if on 7 p.m. I have given leave to the junior counsel, and at 9 p.m. I have left her at court mode. So the CCTV shows at 4:49 p.m. I have left her out of goodwill, and I showed my good gesture when this junior came that why didn't your senior come? Why you came? No, your senior has to rectify the report, or else we'll take the disciplinary action. This thing has been lost after 3 days without any.
When the report was submitted?
Report was submitted, Lordship, on 9th, Lordship.
On
Lordship, those documents, Lordship will not find there because
on 9th of?
Or 8 days.
8th of
8th
of December.
Not December.
And the incident alleged to be
On 10th of December. But the FIR loss after 3 days.
No, that report is which report?
The report submitted by the senior of the.
When he was submitted,
it was submitted on petition On 8/12/2025, the forgery was caught by the bank.
No, what is the date of the report?
Date of the report. It should have been because this is the main point. But if I pray once.
So what do you want? This is a good. It's a good defense. How the 227, 220 in the CRR? How it
Now the case is the allegation that I have inappropriately touched her in the vehicle does not stand as because the time when I have touched is brushed aside from the CCTV footage.
Correct.
Number one. Number two, the cause why she has lost this complaint, we have document to show that she had the definite ground, and upon instruction by her senior, she has lost this false and frivolous complaint. Number three, the investigation has been completed and charge sheet has been submitted. We filed a petition for quashing before this court, which was kindly comes to Lordship. In another, there is another matter. In page 20, Lordship will find we were directed that after the submission of the charge sheet to apprise this court, and charge sheet was submitted from the charge sheet, Lordship, no supportive evidence, only hearsay, no supportive evidence of whatsoever. On the contrary, the CCTV footage and other documents.
How many witnesses are there in the charge sheet?
Charge sheet possible fine. Seven witnesses.
Where is that?
Last but second last page of the charge sheet. The three witnesses whose 161 I have annexed are all hearsay, and they say that at 7 p.m. She was taken in the vehicle and 9 p.m. she was left.
Correct.
But the CCTV footage shows that for 59 hours she was left from the same place. So no incident can happen during the tenure period she is alleging of.
Who is the Pritam Muhari?
Pritam Muhuri. Witness, Lordship.
Who is he?
Lordship comes to page 25.
Correct, 25. I am there only. I would like to insert that. This one.
Friend, Lordship, friend. Associated lawyer under the same. So once again, Lordship, 7 p.m. he was taken in the vehicle and 9 p.m. dropped. On the same place, the CCTV shows at 4:59 p.m. she was she came out from the vehicle, waved her hand and went up. So how can any incident happen at 7 and 9 p.m., which is conspicuously absent in the CCTV footage? She declined the medical event.
Without, what is without certificate of? What is the page 27?
Page 27, okay. Page 27. the serial list, the CCTV,
Uh,
which the police collected.
correct. Ankita Datta.
Getting out of the car at around 16:57.
Correct.
And walking past the road after getting out of the car around 16:59.
Correct. At the court mode.
At the court mode.
Opposite Treasury Building.
Treasury Building, SM Road.
SM Road.
Without certificate on section 63. The certificate of field date has not been collected by the police. The CCTV has been collected. This is the government CCTV, that is police CCTV.
So without a certificate, how it can be relied upon?
Okay, they have subsequently annexed, Lordship. When it comes to page 28. Subsequently, they have it is part of the charge sheet. And 29. District Police Unit, Siliguri Police.
Look. The petitioner has filed the present revisional application under section 528 of the Bharatiya Nagrik Suraksha Sanhita, praying for quashing of the charge sheet being number 114 of 2026 dated 7 February 2026, arising out of Bhakti Nagar Police Station case number 1183 of 2025 dated December 10, 2025 under section 74/76/78/127 within bracket 2/64 within bracket I/62/351 within bracket 2/61 within bracket 2 of the Bharatiya Nyaya Sanhita 2023 pending before the Learned Court of Chief Judicial Magistrate of Jalpaiguri, being GR case number 3323 of 2025. And counsel for the petitioner submits that the police of PS Bhakti Nagar has registered the above case on the written complaint of the complainant dated 10th December 2025. Full stop. He submits that as per the complaint, the victim has boarded the vehicle at 7:55 p.m. 7:55 p.m. and as per the instruction of the petitioner, the complainant has seated at the backside along with the petitioner, wherein the petitioner has committed the alleged offense, and finally, after the resistance of the petitioner, the petitioner get down from the vehicle at 9 p.m. At Court Mode, Siliguri, wherein the petitioner has threatened the complainant with dire consequences and directed not to disclose the incident to any person. Full stop. Counsel for the petitioner submit that after completion of the investigation, the police has submitted the charge sheet. During the investigation, the police has obtained the CCTV footage of from where? CCTV footage of Court Mode, wherein it is mentioned that Court Mode, and after obtaining the said CCTV in the pen drive, wherein it is found that the victim getting out from the car at 16:57 hours and walking past the road after getting out of the car at around 16:59 hours at Court Mode, opposite Treasury Building, SME wrote, full stop. SMC wrote. Learned counsel for the petitioner submit that as for the case of the complainant, the alleged incident was occurred in the car of the petitioner from 7:55 p.m. to 9 p.m. But from the CCTV footage, it is found that the victim was already came out from the car at the college mode, at the court mode at 16:57 hours. 16:59 hours. 59 hours. He submitted that from the said statement, the statement of the victim is not corroborate with the CCTV footage which has been collected by the police during the investigation. He further submit that the petitioner, the senior of the petitioner is the impanel advocate of the bank, wherein the petitioner is working as senior manager. He further submit that there was some dispute with regard to the report submitted by the senior of the Leonard senior advocate of the petitioner, senior advocate of Leonard panel advocate of the bank, who is the senior of the petitioner here, of the de facto complainant hearing, and due to the said grudge and enmity, the petitioner and the complainant has made a false complaint before the police authority against the petitioner, who is the chief manager of the said bank. Police consider the submission made by the counsel for the petitioner, peruse the FIR and the charge sheet and the seizure list. This court finds that the petitioner has made out the arguable case, which is to be decided only after giving an opportunity of hearing to the state as well as the de facto complainant. Accordingly, petitioner is directed to serve the copy of this revisional application along with the documents to the state as well as the opposite party of it, and to file the affidavit of service on the returnable date. Pending disposal of the present revisional application, the proceeding, it has not been committed to the Sessions Court. The pending disposal of the revisional application, the proceeding in connection with the GR case number 3323 of 2025, pending before the Leonard Court of Chief Judicial Magistrate of Jalpaiguri in connection with Bhakti Nagar Police Station case number 1183 of 2025, dated 10th of December 2025, is stayed for a period of 8 weeks from date. List the matter.
Leave may be granted for telling supplementary.
The counsel for the petition submit that he, after filing of the present revisional application, the petition has got further document which is required to be filed in the present application in support of the case of the petition and prayed for file supplementary affidavit. Let the supplementary affidavit filed within a week after serving the copy to the land council for to the opposite parties. List the matter on 11th of June 2026.
31 is my vehicle lordship. Who was driving the vehicle, but rape charges are seen.
उसमें ना दोनों करके कर CRR कर विथ करके कर दो उसमें कर देना पिटिशनर इन so is the driver of the petition in so
32
32 None appears on behalf of the petitioner. No accommodation is sought for. This court finds that the petitioner has filed the present revisional application, being agreed and dissatisfied with the order passed by the learned Chief Judicial Magistrate Alipur Dwa in GR case number 2446 of 2025, dated 21st of January 2026, wherein though the investigating officer has filed the report raising no objects, filed the report stating that the investigating agency has no objection for release of the said vehicle. But the court was of the view the director of the company has not come forward for release of the said vehicle. Accordingly, the London Trial Court has not passed any order for release of the vehicle. Consider this, peruse the order impugned. This court find that there is no illegality in the said order. Accordingly, revisional application is dismissed. Sierra, na? Revisional. Next. 33. I will give my brief. What is where is the order? Setting aside the judgment passed by so and so in connection with MR case number 125. Who are you? Husband. Who is the petitioner? Wife. Who is the petitioner? Wife. How much amount? The instant application maintenance so and so is allowed with cost. Opposite parties director paid to go on paying the 10,000 rupees per month to the petitioner toward the maintenance, and rupees 17,000 to the daughter, and rupees 7,000 per month to the minor son till attains majority. The said amount shall be paid by the opposite party every month. Yes. So this order was passed by whom? Passed by Additional Chief Judicial Magistrate. And you file the revision application here. Why? Why not the Sessions Court? Huh? Why not the Sessions Court? No. I find here you all peoples Filing application, dragging the matter, sending the report to the Supreme Court. Matters are pending, the judges are not disposing of. And when the judges are taking the matter, senior is out of his station, my leg has broken, and
Just let me inform my senior.
who is your senior? Why you not have here? Since morning he is in court number 7 only. This is the 4th case and he is in court number 7. Since morning I have heard for 7 hours, 4 cases is court number 7. What is the wrong in the order? What you are doing? What is your service? Also,
34.
Mr. Shah, yesterday that 4 matters, na? While I signing, I find that re-hearing is required. I will fix the matter tomorrow as to be mentioned. You inform the other side, state. Because 2 matters you have not disclosed the charge sheet. How the court can go in? In the 2 matters you have not disclosed the charge sheet. 2 matters I didn't find, that's why. It will come with the total details of the each and every case brief. So I will hear on merit on that. I will fix tomorrow. I'll fix tomorrow, inform that. While signing, I find that it has to be re-heard. So I will fix the matter. Yes, what is the matter? Hmm. 12th of May? Section 160 notice issued to whom? Accused.
No, I don't know whether I'm an accused or still I don't know. I am an accused.
Who is appearing for the state? Mr. You are appearing? You are appearing? Have you CD? Why 160 notice is issued? That is the only question. CD call 365. IPC 365. APPD, 511. If 160, whether is a witness or with the accused? The accused 41. Kotwali. As per the prayer made by the council, learned APP in charge, praise for producing the case diary. Let the matter appear on 21st. Next.
35.
You inform the case number to Mr. Actually, he has filed 4 criminal revisional applications. Wife has initiated 4 FIR, 4 charge sheet, 498A. Actually, I passed an order, but while I signing that, I find that re-hearing is required. So I will list the matter tomorrow. You go through it, bring the CD. I will fix tomorrow as to be mentioned. Then I will fix the date day after tomorrow, whatever it is. It will come tomorrow as a to be mentioned.
35.
Yes. What is the CRR? Under section 406. Huh? Yes.
I would like to inform you that I am one of the partners of Municipal Cafe, and we located at another missionary charity, missionaries of charity, stable yesterday. On conversing with Mr. Bishop, he mentioned that he was a leader of export generator and strongly suggested that we purchase a new generator from him. Likewise, I visited Mr. Bishop Cole's office in such to discuss the purchase of the generator. Later, I explained that we did not have sufficient funds to purchase a new generator, and Mr. Bishop said that we had good terms with some finance person and would initiate the process of loan to one of his contacts. On the recommendation of Mr. Bishop, one gentleman, Mr. Rameshwar Singh, was the petitioner.
Yes.
Employee of Kotak Mahindra Bank, who starts for bank funds. The documents required for financing the generator were submitted. All necessary criteria for sanctioning the loan were made, and the necessary loan was sanctioned. The down payment of the generator was done in 2 installments via Google Pay into the amount of the power value and fuel solutions. The details of this are done. The remaining amount of rupees 2,74,255 was financed by Kotak Mahindra, and the funds were released to Mr. Bishop on 26 September 2020 without the delivery of the generator to the owner. Here, Mr. Rameshwar Singh was supposed to verify whether the 20 kilowatt export diesel generator had been delivered after due payment. Mr. Rameshwar, for reasons only known to him, failed to act strictly in this matter. I made numerous attempts to get in touch with Mr. Bishop on the delivery of the generator, and at very attempt made from my end, Mr. Bishop kept postponing the delivery dates. This can be seen through the conversation with Mr. Bishop on the WhatsApp group specifically created for all communication related to 20 kilowatt diesel generator. Once the monthly EMI of rupees 9,705 started getting deducted from the current account of the user, I again reminded Mr. Bishop about the delivery generator. And Mr. Bishop came to meet me at the Google Apple at the beginning of 26 November 2022. And in this meeting, he made commitment that he would bear 2 EMIs from his end. The proof of this commitment made by Mr. Bishop is evident in the email sent by him. As usual, Mr. Bishop did not honor his commitment. I again tried to get in touch with him, and as usual, he made several excuses for not being able to deliver on his words. I would like to point out that Mr. Bishop delayed practice has caused us loss in business due to power cuts and not to mention the tremendous financial stress caused by the entire asset. In the meantime, due to the excuses, constant lies and long delay, I was compelled to send a legal notice dated 6 January 2023 to Mr. Bishop. I will refund all the payments made by him with due compensation within 10 days of receiving the legal notice. After having received the legal notice on 19 January 2023, Mr. Bishop contacted Mr. Gyanendra Diwan, a criminal lawyer who on my instruction had sent the legal notice upon received the instructions from Mr. Rishabh Paul, that is the saying that he has been paying our monthly EMIs and the matter concerning the related has been resolved. Yet another lie by Mr. Rishabh. When Mr. Ganendra asked Mr. Rishabh to give proof of the EMI payment, the Murabha Mr. Rishabh was not furnished any proof of payment. We, the partner of Murabha, have given more than enough time to Mr. Rishabh to resolve this matter. Adequately, honor all commitments to return all payments with the contribution made to him. Pay our EMIs, monthly EMIs, and close the protect of the bank. At every attempt made by us to settle the matter, Mr. Rishabh has deliberately used delay tactics, citing numerous excuses to not resolve this matter. Finally, at the last resort, I am happy to lodge the FIR because all attempts made from my end may not yielded any result. I humbly request your esteemed. This is the complaint which will be registered under section.
So who are you? You are?
I am Mr. Rishabh, who has.
No, you are Rishabh.
No, I am.
Gyanendra. Gyaneshwar. Rameshwar.
Yes. My only allegation against you is that I have processed the loan. I have collected all the documents and submitted, and the loan was processed. Sanction. This is the allegation against
you. Mr. Singh, Vedana, employee Kolkata, approach of the bank and Bullock financing generated all the necessary criteria. So you are sanctioned the law.
Yes. I'm bank has sanctioned. I'm the one who has collected the documents and submitted.
Yes. So what has happened now?
This complaint has been lodged against me. So there is nothing against me.
Where is the charge sheet? Charge sheet filed? Charge sheet not filed.
Yes. Supplementary is written filed. Can you see supplementary? I've added the charge sheet. Page 4.
During investigation, other evidence written from 406. How the 406 has come? Rameshwar Singh.
And it comes to the third last page of the third last page of the petition.
Which one?
Third last page of the petition. And this is the petition submitted by the complainant in the court bill.
Third last page.
This is the submission.
Application dated?
Dated 10th May 2020. Your commissioner issued a criminal complaint on 1st March 2020, and thereafter a specific case was started against the above named accused person, Videsh Shiduri police station case number such and such.
Correct.
That after institution of the present case, there has been an out-of-court settlement between the petitioner and the accused person, and the disputes have been resolved accordingly. There have been absolutely no force pressure used upon the petitioner, anyone whatsoever. The matter has been resolved by and between both the parties and petitioner, and also personally does not want to proceed with the case. But still, the further petitioner has no objection to the various by the accused person.
Yes. Who is for the state? But the charge sheet is filed. Charge sheet filed against also. Charge sheet is filed.
Against the Rishabh Paul and the present petitioner.
Yeah, Rameshwar.
on the complaint itself, there is no allegation against the petitioner.
Where is the state? Aditi Shankar Chakravarti is not here. So what can be done? Inform. He was there. Mr. Neela was here. Inform. I am keeping debtor tomorrow. Learned counsel for the petition has argued the matter at length, but none appears on behalf of the state. The petition is directed to inform the learned APP in charge. List the matter on 20th. $36. Yes. Have you communicated this order? Where is the affidavit? Order dated 12th May. Have you communicated? No. To whom? Whether it's delivered? Item delivered address. Yes. What is the matter? But without the CD, you're not file the charge sheet. Where is the charge sheet? Where is the charge sheet? Who are you? Sole husband.
Can you see the second page of the charge sheet? The act of the 31st March 2021. The legal complaint with the affected complaint was married. The moving complaint as per implies and custom all changing. 10th January 1991.
Yes.
But since the marriage, he was subject to also legally disciplined.
1991. Where from you are reading?
Second page of the charge sheet.
Yes, 10 January since the marriage subjected to torture. 1991 marriage was solemnized.
After 30 years, the complaint was 30 years.
You submit. Where is the evidence? Where is the 161 statement? Who is the PW1? Who is the witness number 1? Rupa Roy?
Rupa is the wife.
Is the complainant. And Sandhya Roy?
Sandhya is the mother.
Mother. Krishna Chaudhary? So where is the statement of the other witnesses?
Yes,
where the wife resides? Now? Not with you. This not issue.
No issue. Yes, will be Korea.
Where is reside?
With the mother.
He is the witness here.
No, witness here was not examined by that.
Here in this charge sheet, there is no name of the witness.
Yes, David Roy.
David Roy. What is stated in the evidence? What? But nobody say what can be done. It has to be. Correct, but the CD, nobody is there.
There is no date, no time of the age torture. Now, 1991 to 2017. 2017. Decide together. That's 17 million. Some dispute brought, they reside in her mother's.
Then charge sheet, nothing. Your police is not writing anything in the charge sheet.
Last page, half page of the charge sheet. Kindly see. In course of investigation, kindly see.
I have gone through, but where is the IO? What can be done? Without hearing how the quashing application can be taken. In spite of the direction passed by this court, no CD has been produced. None appears on behalf of the state. The petition is directed to inform the next date of hearing to the learned APP in charge. Let the matter appear day after tomorrow. Next.
37.
No state. Next.
38.
वो दे दो. Yes. 38 who is appearing? You are appearing? Next.
39. 40.
What is that? Quashing?
The petitioner was convicted in the magistrate court. They can give them as it was preferred. Then division application has been prepared. Admitted and fees are right now on bail. Now paper books directed to be prepared. I don't know whether it has been prepared.
Yes. Next. None appears on behalf of the state. Record current. 39. None appears on behalf of the state. Yes. So why you are sleeping there? When the court is dictating, then you are coming. When the court is going to pass an order, then you are watching. You are watchdog. Who has sent you to the court? Yeah, to keep watch upon the court. None appears on behalf of the state. Let the matter appear before the next available circuit bench.
42. 41.
Next.
43.
'Item number?
41.
41. Give the 41. It appears the records were called for by the law, by the school, by another. It does not appear the record has been brought. Record আছে কি?
No, 41.
हाँ? कोई record आया? Yes, what do you want?
I lost the brief, so I want a copy of that brief. It will be available for the record itself so that I can.
What brief? CRR? You apply for the certified copy. What your challenge in this? Sub-regional officer, which order your challenge? Call for the record NGR case number so and so instead of the order pending before the London Executive Magistrate the order. What do you challenge?
I try to recollect what I believe that I have challenged notice of 107. But that notice has been served upon me without the cease of the allegation. But the law mandated the magistrate when a notice, someone is issued under section 107 or 110 of the criminal procedure, you will mandatorily attach or accompany with the gist of the allegation. So that I can enlighten myself regarding the allegation against which I have to sought for to find bond. That has not been done. So there is a paper of judgment on the Office Honorable High Court, our High Court, and this frivolous notice is done without accompanying the gist of the allegation. No mandatory compliance is required, and that has been said extremely aside. There are a couple of them.
What is your name? Huh? Ajay Roy. The petitioner has filed the present regional application challenging the notice issued by the Executive Magistrate Dinhata in NPR number 615 of 2023 dated 18th of August 2023, wherein the petitioner is directed to appear before the Executive Magistrate Dinhata on 1st of November 2023. Learned counsel for the petitioner submitted the Executive Magistrate Dinhata has issued the said notice, but the said notice does not reflect any gist, any details of the proceeding in which the notice has been issued to the petitioner to appear before the Executive Magistrate Dinhata. This court, by an order dated 30th October 2023, directed to call for the report of NPR number 615 of 2023 dated 18th August 2023. The Executive Magistrate has submitted the record of NPR number 615 of 2023, NGR number 340 of 2023 under section 1110 of the CRPC. This from the record, this court find that the Inspector in charge Dinhata Police Station, Kuch Bihar, has submitted a report for prosecution under section 110 of the CRPC against the petitioner. Full stop. On receipt of the said report, comma, the executive magistrate had registered the above case and issued the notice. Full stop. Consider the above, full stop, and issued the notice. The order dated 28/8/2023, by which the executive magistrate Dinahata has issued the notice to the petitioner, comma, the said order does not reflect that the said case has been initiated. The said case has been initiated on the basis of the said case has been in the said order does not reflect any reason as to why the case has been initiated. Full stop. Considering the above, the order dated 28/8/2023, by which the notice has been issued to the petitioner for appearance before the magistrate London executive London executive magistrate on 1st of November 2023 is set aside and cost. Accordingly, notice dated 10th of October 2023 is also set aside and cost. However, this order will not prevent the executive magistrate Dinahata for taking appropriate steps against the petitioner in terms of the report received by the executive magistrate from the officer in charge, Dinahata Police Station, in accordance with law. CRR is disposed of. The proceedings of NPR number 615 of 2023, NGR number 340 of 2023 under section 1110 of 1110 of the CRPC, forwarded by the executive subdivision magistrate Dinahata, Kuch Bihar, be sent back to the subdivision magistrate Dinahata, Kuch Bihar, for taking appropriate steps immediately. Yeah, send back immediately for taking. Next, 42. Yes. None appears on behalf of the state. Let the matter appear before the next circuit. Next, 43. Give. Yes, who is for the petitioner? Yes. Section 5 application. Why Section 5 application? Yes.
I was initially directed to solve the problem.
Since 2024, your Section 5 is pending. I am dismissing herein now. Sorry, Jantandra Chatterjee or anybody. 2024. Sorry. You argue the matter. Section 5, even you persons are not able to argue the matter. Why you are practicing here? 2024, I will not allow. You know, Section 25, 20 days delay. And 25, now 26, 2 years for the 20 days delay application hearing. I am dismissing. Then argue the matter. This court find that this revisal application has been filed. Yes. 448, 427, what the revision? 500 rupees fine.
Kindly come to the paragraph number 2.
What is the revision? You tell me the revision first. Let me understand what is the merit in the matter. Where is the judgment? Where is the judgment?
Petition before the project manager of Jalpaiguri, project.
Who are you?
I am the project manager.
Nah.
The allegation that in the opposite party that they are occupying my quarter. Quarter, they are occupying my quarter. I have made an application. I have made an complaint before complaint to the person. If I have been lodged, they have appealed. And again, you have appeal for the district session judge. Thereafter, I have challenging the problem. The private officers, they are occupying my land, government property.
But you have not produced any document during the trial that this quarters have been allotted to you, that the electricity is in your name, that this property belongs to the Hydel Project Limited. So where is the document? Show me. The petitioner has filed the present revisional application challenging the order passed by the learned Judicial Magistrate First Class Goru Badan dated 18th of June 2022, wherein the learned magistrate has acquitted the accused persons for the alleged offence under section 448, 427/34 of the IPC and acquitted the accused person under section 255 within bracket 1 of the CRPC. Being agreed and dissatisfied with this order of acquittal, the petitioners have preferred and every matter cannot be too much. Maybe. Being agreed and dissatisfied with the order of acquittal, the petitioner has preferred an appeal before the learned session judge Kalimpong, being criminal appeal number 6 of 2022. The learned sessions judge Kalimpong has dismissed the appeal preferred by the petitioner and affirmed the order passed by the learned magistrate. Now the petitioner has preferred the present revisional application challenge. Now the petitioner has filed the present date application, present revisional application. Full stop. This court find that along with the present revisional application, the petitioner has also filed an application being CRAN 1 of 2024 under section 5 of the Limitation Acts for condoning the delay of 20 days in filing the present appeal. By an order dated 13th February 2024, this court has directed the petitioner to solve the revisional application along with the condonation delay application to the opposite parties. This court finds that since the year 2024 till date, ना केटे थे फाइल दी क्या बोला?
I have
Last में क्या बोला? ठीक है. By an order dated 17 May 2024, Crane 1, the condonation of delay is the delay of 20 days was condoned, and Crane 1 of 2024 was disposed of. Since then, the criminal division is pending. The matter was taken up for hearing on 24th of July 2024. None appears on behalf of the petitioner. The case was adjourned. On 29th July 2024, as per the prayer made by the counsel for the petitioner, the case is adjourned. On 2nd January 2024, none appears on behalf of the petitioner. On 7th January 2024, none appears on behalf of the petitioner. On 17th March 2026, none appears on behalf of the petitioner. On 18th March 2026, as per the prayer made by the counsel for the petitioner, it is not 18 March. 18 is 17 March. None appears on behalf of it. Today, when the matter is taken up for hearing, learned counsel for the petition again pressed for time. This court find that the learned magistrate has passed an order of acquittal against the opposite parties, has passed an order of acquittal of the opposite parties on the ground that the investigating officer has not seized any document during the course of investigation to establish that the staff quarters, which was allegedly to be occupied by the opposite parties, have been allotted to the petitioner. The prosecution failed to prove that the said quarters belongs to HON'BLE project. The London magistrate has further finds that none of the witnesses identified the accused persons by names or by face. The prosecution failed to prove during the trial that the accused persons are illegally occupied the quarter of the petitioner. Full stop. The London magistrate has further recorded that during the investigation, the investigating officer has prepared the sketch map and index and submitted that there are only 8 houses oblique quarters at the place of occurrence. But in the complaint, it is mentioned that 13 families have forcibly entered into the staff quarters. But there is no 13 quarters available at the spot as per the sketch map prepared by the investigating officer. Police opera. This court perused the record, evidence, and the judgment of both the court, that is the trial court as well as the appellate court. This court did not find that the petitioner have proved that the government quarters which the petitioner is claiming has been allotted to the petitioners or the opposite parties have occupied the said quarters illegally. Considering the above, this court did not find any merit in the present divisional application. Accordingly, divisional application is dismissed. Next, affidavit of service filed by the petitioner be kept with the record. Next.
44.
Yes.
Last instruction, my lord, we would like to raise this. The opposite party want my client.
What is the divisional application?
The allegation of complaint was filed at the Central Court.
You are appearing for complainant.
I am appearing for the find an order passed by this honorable court dated May 2nd, 2024. In lordship, there is a direction upon the petitioner to return all the Supreme articles in presence of the police authority, that is the respondent number 2, your lordship, and that has already been complied. And on the last page, an application, your lordship, showing the compliance, your lordship.
No, where is the order? Where is the order?
Order is dated May 2nd.
Acha, yes, sir. You have received?
Yes, my lord. We have received all of it. And my lord, from the official mail account, my client, she has also mailed us saying that they have received. I would like to place.
I have filed the affidavit in compliance, your lordship, on the last occasion. Can I get a copy of the mail?
I'll just send you.
Yes.
So that is the situation.
Where is your complaint?
Page 38, your lordship, that is the CR. This
Page
is a
30.
39 onwards, that is Annexure E, your lordship. So this is a CR case, your lordship.
You are appearing for all?
Yeah, all the three accused.
One is the husband.
One is the husband, 2 is the father-in-law, and 3 is the mother-in-law.
So after initiation of the case, the court has taken cognizance. What has happened after filing of the case?
Yes, your lordship, and the police has inquired. The report of inquiry is at the last page, your lordship, from where is it would suffice that all the articles were also lying in the house and in the bank locker, your lordship, which wasn't opened. The last page of my petition,
During
your lordship.
inquiry, one of the accused person nonsense. So you filed the CR case.
The opposite party number 1 filed.
You have filed the complaint case. Yes. On the complaint case, the inquiry report has been called for.
Yes.
On receipt of the report, it was found that some articles were lying in the house and the bank account. Then what has happened?
Subsequently, as per the orders, we have also collected it. We have received.
Just then what has happened?
Subsequently,
So why the revisional application?
For quashing of the complaint case, your lordship, and that was heard, and stay was granted by an order dated 12th of December 2023, your lordship. Till disposal, the stay is there, your lordship. So And subsequent to that, Your Lordship, Justice Shubhra Ghosh, Ladyship heard this matter at length, Your Lordship, and directed that in presence of the state authority.
The petitioner has filed the present petitioners or petitioner?
Petitioners.
Petitioners have filed the present revisional application. Have filed the present revisional application. Petitioners have filed the present revisional application, praying for quashing of the proceedings and all orders passed in CR case number 438 of 2019, pending before the Learned Judicial Magistrate Court, Siliguri, under section 406/34 of the Indian Penal Code, initiated by the opposite party number
1.
Opposite party number 1. Opposite party number 1. Full stop. Number next. On receipt of the complaint filed by the opposite party number 1 before the Learned Magistrate, comma, a report was called for from the IC PS Durgapur. PS Durgapur.
IC City Center.
IC City Center PS Durgapur. IC City Center PS Durgapur. Full stop. In compliance of the full stop, the IC City Center PS Durgapur has submitted the report dated 2nd November 2020, wherein it is stated that during the inquiry, it was found that as per the list provided by the opposite petition number OP number 1, but serial number 29, 30, 31 exist in the house, and the jewelries having serial number 1 to 17 are kept at the bank locker of the petitioners of the petitioner number 1. Full stop. The matter was taken up for hearing by this court on 2nd May 2024.
First, Your Lordship, the matter was heard on 12th of December 2023.
The matter was taken up for hearing on dated
12th of December 2023. The matter was first heard, Your Lordship, and stay was granted till disposal, Your Lordship.
When is that order? 1st of December?
12th of December 2023.
The matter was taken up for hearing on 12th of December 2023. And at the time of hearing, this court found that there is a scope of settlement according as the petitioners are willing to return all the jewelries kept in the bank locker of the petitioners, and accordingly, the proceedings initiated by the opposite party number 1 before the Learned Magistrate was stayed till the disposal of the application. Full stop. The matter was again taken up for hearing by the coordinate bench of this court dated 2nd May 2024, wherein both the parties agreed that the opposite party number 1 shall visit the house of the petitioners and will collect the street-hung articles, and the opposite party number 1 shall also visit the bank and will take the gold ornaments from the said locker. Full stop. In terms of the said order dated 2nd May 2024, the opposite party number 1 has received all the articles, all the street-hung, including the jewelry from the locker, in presence of the ICOP In presence of the police authority? No.
In presence of city center IC,
In
police
pres-
station Durgapur.
in presence of the city center IC city center police station Durgapur. ठीक है? Learned counsel for the opposite party number 1 has handed over an email dated 18th May 2026, wherein the opposite party number 1 has informed the learned advocate on record of the opposite party number 1, stating that the opposite party number 1 has received all her Stridhan items as per the direction passed by this court, and she has no objection if the proceeding initiated by her, being CR case number 438 of 2019, pending before the London Magistrate 4th Court Siliguri, is passed. Full stop. Learned counsel appearing for the opposite party number 1 on instruction submitted, he has received the written instruction that the opposite party number 1 has received the Stridhan and the gold and the jewelries, and she is not intending to proceed with the complaint case initiated by her before the London Magistrate. Consider the submission made by the counsel for the respective party, peruse the materials on record, and the email dated 18th May 2026 issued sent by the opposite party number 1 to the London advocate on record of the opposite party number 1. This court find that the opposite party number 1 has received all these Stridhans and she has no grievance against the petitioners. Accordingly, proceedings of CR case number Proceedings of the CR case number 438 of 2019 pending before the London Judicial Magistrate Court Siliguri under section 406 of 34 of the IPC is set aside are quashed. Is quashed.
Deeply obliged, Your Lordship.
Quashed
Grateful, Your Lordship.
Next.
Deeply obliged, Your Lordship.
45. I am for the petition.
Yes.
But actually, on last occasion, His Lordship was pleased to direct the opposite party number 2 to produce the death certificate of the opposite party number 1.
Who is the opposite party number 2?
Mr. Shahapuddar was appeared on the last occasion.
What is the matter?
Matter actually,
107. 107.
107 was initiated against me. I have challenged that.
What ground?
My lord, actual fact is that, so for the relationship is concerned, I am the daughter-in-law of the OP number 1, who has already been expired, and the wife of the OP number 2, and I have been tortured. When I have filed an application for under section 12 of the PWDB Act, just to save their skin, they have lodged a false complaint against me that I am an unchastely woman. And the OP number 1 was the member of parliament on earlier occasion. Being influenced by her, a proceedings was initiated against me. That is the genesis of this case.
When the proceeding was initiated?
Proceedings were
23. Now we are on 25. What remains?
Actually, my lord,
107, 1110, 110, 106. The proceeding is for
1 year.
Not 1 year, 6 months.
That was initiated on the
2 years, 3 years, not 12 December. What remains?
That as your lordship.
What all lordship? Who is for the state? Nobody is there. Nobody is for the opposite party. How the matter can be taken? Not today.
46.
On behalf of the nation. Washing of charge.
No, state is not here.
Yes, state is not here.
Next circuit. None appears on behalf of the state. Let the matter appear before the next circuit.
Similar matter. 47.
47 also, next circuit.
47.
48, quashing of 498 proceeding, amicable settlement arrived at between the parties, a mutual application is required to be filed.
When you filed?
The next circuit, because
Why? If a mutual, why you are not coming here?
Because on the last occasion, the court has directed to file the.
Fourth day of next circuit bench, it is from mutual divorce has been obtained by the private parties being the complainant opposite parties. Petition intimate the complainant. Who is for the other side? Have you saw the notice?
State was earlier occasion appeared.
No, who is for the wife?
Wife has not appeared.
You're not made a party.
No, yes, made party, but the after service, they have secured the mutual divorce from the trial court.
Correct.
Then that
mutual divorce, you're not appeared.
No.
Mutual divorce are the only one. You might have been appeared.
No, both appeared.
So in the mutual divorce, at the time of mutual divorce, you not entered into a mutual agreement.
Exactly.
You will not proceed with
that. Has not been done by the trial.
Where is the agreement?
That has not been done in the trial court. What can be done? That agreement has not been done in the trial court.
So why you are ready for the mutual divorce without the agreement? 498 is there. Without settling the 498, you have given
should
the
not be
consent
done.
for a mutual divorce.
I should not be done. I know.
How you are instructing the clients?
No, I have not instructed. They have arrived at and they have secured the mutual divorce from the trial court below.
As per the prayer made by the counsel for the petition, let the matter appear before the next circuit. Next,
I am for the petitioner lawsuit.
Yes.
49. So this matter, I believe that purpose that it becomes infructuous.
Which one?
That 49.
Why?
Because that I was initially filed this application. Thereafter, trial has already gone, and then the trial is it is fixed for a pronouncement of judgment and all. I believe that it has rendered.
PCR is here.
LCR.
What is your challenge here?
Yes.
What is your challenge?
I have challenged that.
GR case number, impugn proceeding of GR case number.
Yes.
147, 148. How many of these persons?
Same self incident, 2 cases has been registered. That subsequent case has not been investigated by the same officer and not even tried. So it has kept alone while this application, this proceeding has been ended into, gone into the trial and it is on the verge of completion. So this LCR is related to the trial.
No, since 24th, the matter is pending here.
No, trial court has already proceeded with the trial. I believe this is a skeleton copy. That LCR, this is a skeleton copy.
No, original.
Original. But the trial, I have an instruction that trial has already proceeded.
Which CR case? Which CR case? Which crime number? FIR number?
Birpara Police Station 116 of 2023.
No, Birpara 120.
120.
Birpara 120 of 23.
No. 120 ka to no.
Birpara 120.
This is the LCR relating to?
Birpara 120.
120.
And your case is?
My case is 116.
120. Birpara case number 120 of 23. You have so many cases, you're confused, sir.
No, not exactly. I'm assisting Lordship. I'm assisting.
See the cost title?
Yes.
Impugn proceeding of GR case number 118.
No, the husband of the petitioner was arraigned as a co-accused in connection with Birpara Police Station 116 of 2023 with an occurrence of a murder With an occurrence of an allegation
No,
of
no.
murder.
This case is with regard to the GR case number 1636.
1608.
No, 36.
Oh, sorry.
It is 1636 of 2023, originated from the Birpara police station case number 120 of 20.
The main, then I understood. The main case has already proceeded with the trial, and it is the fag of the trial. While this LCR has lying in the collateral case is lying in the before the High Court, it has been kept pending. However, Lordship, it will be let the LCR be sent down, and it will be taking its own course.
So that because it may dismissed.
Because it becomes an infructuous, I believe. Because
why?
Because that trial has already ended.
Trial is with regard to which case?
That earlier case, 116. But this, out of the self-same cause of action, this case was also registered. That the main occurrence is 23rd of August 2023, where one Manoj Lohar was abducted and her dead body was recovered on 26th of August 2023, and an UD case was registered thereupon, and subsequently a formal FIR, Birpara Police Station 116 of 2023 was registered on next date, that is the 24th of August 2023, under section 363, 364, 365, 302 later on added, and 201, 120B of Indian Penal Code. Subsequently, the victim, subsequently a counter attack was suffered by the petitioner. And his house has been gutted down and all. Out of this incident, this FIR was registered. That is one Birpara case number 112. 120. So this case was registered, and I paid before I have come before your lordship for clubbing of the two investigation. That it was lingering. Then in the meanwhile, the main case has proceeded. Now it is lying.
So I am dismissing and sending it to to conclude the trial.
Conclude the trial in accordance with law. Grateful.
Copy may be served.
Sir,
yes. So the petitioner has filed the present revisional application. Present application for quashing of the proceeding of GR case number 1636 of 2023.
I believe not squashing. I didn't pray for squashing. I'm clubbing up two FIR, two investigations.
No, swastika no.
Swastika no.
এটা কি হয়েছে 41 হয়ে যাবে
এটা 41 টা আমরা বলি সিধু এই এন্ড বলি 41
না ডিসপোজাল তো 119 তো হ্যাঁ 290 হ্যাঁ ডিসপোজ
Please to issue rule corners pending You were prayed for a independent investigation, impartial independent investigation.
Yes, because the police, the same police officer, the same police, the police vehicle as well as my house has been torched by the PVA. Initially, the police did not proceed with the investigation.
Correct.
Despite my lodgement of FIR.
Correct.
Then I come before the court that if the police is not interested, then it should be transferred to the another investigation.
Yes. Filed an application. CR so bring. No, rushing order. Present revisional application. Praying for a direction to transfer the case to the competent independent investigating agency to carry out a sincere, fair and impartial investigation into the offense. And counsel for the petitioner submit that submitted after registration of this, submitted that before registration of the present case being Birpara Police Station case number 120 of 2023, dated 28/8/2023, under section 147, 148, 149, 186, 332, 333, 353, 307, 379, 436, 204, 120B of the IPC. Read with section 3/4 of the Prevention of Damage of Public Property Act 1984 and section 9 of the West Bengal Maintenance of Public Order Act 1972, the Birpara Police Station has initiated another case being FIR number 116 of 2023, dated 24th of August 2023. Full stop. Then counsel for the petition submit that during the pendency of the present regional application, the trial of the Birpara Police Station case number 116 of 2023, dated 24th of August 2023, was proceeded for, and this trial is at the completion stage. The trial is at
on the fag end of the trial.
At the completion stage. Completion, full stop. He submit that now, he submit that as the trial of Birpara Police Station case number 116 of 2023, dated 24th of August 2023, is at completion stage before the Learned Court of
Trial Sessions Court. Additional Session Judge.
Additional Session Judge at Alipurdwar. And as such, nothing remains in the present revisional application. And he prays for directing the now it is pending, this matter is pending with the Additional Chief Justice of ACGM. Directing the learned ACGM Alipurdwar to expedite the trial of the instant case. Correct?
Yes.
At the learned counsel for the petitioner, learned APP in charge. This could find that though the petitioner has filed the present writ application praying for transfer of the instant case, transfer of Birpara Police Station case number 120 of 2023, dated 28th of August 2023, to an independent investigating agency for carrying out the impartial investigation. But during the pendency of the present revisional application, the investigation is completed.
So I don't know the latest status.
During the pendency of the present application, the other case initiated by the police, during the pendency of the present writ application, investigation has been completed and charge sheet has already been filed. And the other case initiated by the police being Birpara Police Station case number 116 of 2023, dated 24th of August 2023, has already been at the stage of completion of trial. Thus, this court did not find any justification to pass any order in the present writ application. Accordingly, CRR number so and so is dismissed. Full stop. However, the learned trial court is directed to expedite the matter as per the expedite the trial fully. CRR disposal.
Earlier, 3 matters have been disposed of for 41, 43.
The department is directed to send back the trial court record trial court record of GR case number 1636 of 2023 arising out of Bipara case number 120 of 2023 dated 28th of August 2023. Immediately.
41, 43 and 44.
उनका नाम लिख देना 41, 42,
43 and 44. मतलब our appearance नहीं लिखते.
ठीक है बोल देना.
Item of 50.
Yes.
Self-some cause of action. Two FIR was registered. Investigation going on. I had pled before the court that since the self-some cause of action 2 FIR was there, cross case, one common investigator to be appointed or one investigation to be engaged, and both the investigation to be carried out by the common investigator as per the settled law by the Honorable Apex Court. This is the humble prayer, nothing else.
Yes. What is the stage of investigation?
That
So you have to see if it is completed, then it will be difficult. Come to know the Learned APP in charge is directed to produce the case diary tomorrow. Let the matter appear tomorrow. This number. Next.
51.
$51.
Do to us.
None appears on behalf of.
I'm praying for short passover, Your Lordship.
To whom you are appearing?
I'm for the petitioner, Your Lordship.
Union of India?
No, petitioner.
Yes, Union of India is the petitioner. Which item?
50? Yes, my Lord, 51.
Huh?
51.
So what is the wrong in the order? Union of India has preferred this revision application. On whose behalf you are preparing for?
My lord, kindly see the name Poitu Jaiswal.
Huh? No.
Oh, sorry.
The Union of India has preferred this revisional application, being revisional application against the order passed by the learned Chief Judicial Magistrate Alipur Dwar, dated 7th of December 2023 in GR case number 1919 of 2023, wherein the learned magistrate has released the seized vehicle in favor of the petitioner, in favor of the respondent number 1, in favor of as interim custody with the condition on executing a bond of rupees 50 lakhs and shall not and further conditions on further condition that the opposite party number 1 and party number 2 shall not change the nature, color, character, ownership and possession of the vehicle, and shall not sell or dispose of the said vehicle during the pendency of the case, and shall produce the same before the court as and when required by the court. Full stop. This court find that time and again the matter was listed, but one or the other reason, the learned advocate appearing for the petitioner prays for adjournment. Today, when the matter is called, none appears on behalf of the parties. No accommodation is sought for. Consider the impugn order. This court find that the learned magistrate has passed the order for release of the vehicle as an interim custody, imposing certain conditions. This court did not find any illegality in the impugn order. Accordingly, CRR number 1 disposed of. Crime किया है. Disposed of. Accordingly, crime is also disposed of. Next, 52.
Yeah, I don't know 52, my lord. I'm playing for short pass over. Short pass over, lordship.
52. Not today. Next. 53.
Hmm. 10,000. Good.
None appears on behalf of either of the parties. No accommodation is sought for. Let the matter be listed before the next circuit bench. Next.
54.
Same order. Next.
55.
Lordship, I'm for the petitioner in 55.
Yes.
Lordship, this is for quashing of a GR case number 560 of 2024 in connection with Ghokshadanga case number 184 2024. Lordship, previously the OP number 2 had preferred a complaint case against the present petitioner.
What is the offense?
Lordship, the offences say under section 420 and 406 and 506 of the Indian Penal Code. Lordship, for the facts of the matter is that the OP number 2 had previously made a complaint case against the present petitioner, but the same was dismissed due to non-prosecution. The OP number 2 had made a complaint case
against you.
Yes, sir, Lordship. But the same was dismissed for non-prosecution.
Correct.
On the date of 27th of March 2024. On the very next day, entirely suppressing this fact, the OP number 2 had again made this FIR on the same cause of action. Therefore, your Lordship, I am praying for quashing of this matter.
Why?
Lordship, the matters are completely unfounded and had been preferred due to malicious intent, only to harass the petitioner out of his own personal grudge. If your Lordship will kindly come to page number 19, page number 18 onwards, annexure P4, that is the orders of the previous complaint case. Lordship, after making the complaint case, the de facto complaint
Page
had
number?
Page number 18.
Received a complaint on behalf of so-and-so. Wakalatnama files in petition registered CR case.
Yes, your Lordship.
Today's
After
fix or
the-
essay, no steps, yes. Then
The
today's
de
fix or
facto had not taken
no
any
dismissed.
steps. Dismissed. Your
Correct. They are dismissed when 27th of March 2024.
Yes, your Lordship.
Yes, then
On the very next day, that is on 28th of March, this
Very next day.
this de facto complaint had preferred this current FIR.
23rd of April.
23rd of March. Your Lordship.
Where is that?
If your Lordship will kindly come to page number 16, that is the CR case, the written complaint of the CR case.
16.
Yes, your Lordship. The entirely similar with the present FIR. That is on page number 10. Entirely similar, without any change in the subjects.
Okay, so this is the page number 16 and page number, what is the page number 10?
Page number 10 is the current FIR regarding which I'm praying for quashing.
To the London ACGM,
Yes,
Mata Banga, treat the FIR number 50 of 2024.
It was a 156.3.
Yes, 156.
Starting up to me. But thing is that the complaint was dismissed for default, and then again they have filed a complaint. Which
28th of March.
They come under section 156.3.
Correct.
Later on, it has been raised.
Oh,
Now, they have
completely
said they have
suppressing that.
suppressed. It is suppression of the earlier count.
Yes, your Lordship. There is complete suppression of fact. If your Lordship will kindly look through that FIR, that is from page number 10 to 12 onwards, there is not a single mention that the complaint case was lost and which has been dismissed due to
What is the page number 13?
Page number 13. Page number 13 is the formal FIR, your Lordship.
That is FIR 184.
Yes, your Lordship. Formal FIR of the complaint 156.
Dated 21st of April. 21st of April.
Lordship, the FIR which was made as a treat FIR under section 156(3) before the learned magistrate. After making that FIR, this formal FIR was registered.
Correct.
Yes, sir. After that, there is no progress in the matter. The de facto is not even appearing before the court. And this matter is pending since long, without any progress in the matter. Lordship,
So
this,
what is the stage of the investigation of the FIR of 21st of April?
Lordship, the charge sheet has not been submitted yet.
Ah.
And there is no progress, Your Lordship.
So what you want? Without
Lordship,
the progress, whether the proceeding can be caused.
Lordship, it can be caused because there is no progress. Even the de facto complaint is not taking any steps before the
How the
learned
de
reward.
facto complaint will take? De facto complaint made a complaint. Whatever it is earlier, it was a CR case. Subsequently, she has made a complaint 156(3). Court has passed an order. FIR is registered. Correct. So what the de facto complaint will do? The police authority has to investigate the matter. Either police has to file the final report in final form, or
They
the charge sheet.
Till to this day, they haven't yet filed any final reports. Your Lordship.
The previous complaint, which have been disposed of very
That is not married. Dismiss for default.
So dismiss fine. There is no bar.
They're dismissed for default. You can take the plea during cross, whatever it may be. That is not the ground for causing. Correct. But that is not continuing. That has been dismissed. If both are continuing, then the court could have been appreciated. Either they have to drop one, or the both has to be clubbed together under 210 of the CPC, CRPC.
The entire case is based on the suppression of fact.
What is the suppression?
They have completely suppressed that there was a complaint case before.
Complaint case is dismissed for default. They have not appeared whether they have filed a restoration or whether that has been restored. Then they made a 156(3).
Then I will take further instruction.
What instruction? Tell me.
The instruction is from their time. The state of investigation, whether they have been taking this case for the learning also.
Correct. She will not do before me. She is not interested to do before me.
Our only point is that
Correct.
suppression has been done. If that would have been in the 156.
Suppression, madam. I find here all persons are coming within FIR for quashing. Okay, there is no bar. But see, FIR, then investigation, unless and until the investigating authority will not given the chance to investigate, how the court can only on the basis of the FIR? FIR is what is it? Encyclopedia. Correct. So you have to say, if the charge sheet is filed, then you can challenge that it is whatever it may be. Can you bring the CD? Which PS?
If they want to
as per the prayer made by the counsel for the petition, let the matter appear before the next circuit bench.
56. 56.
Why? GM court is vacant, then you could not serve the copy.
Advocate was appearing, the law court will not accepting the
138. What is the transfer of case? Where the check was issued? When it was dishonored? Where it was dishonored?
It was dishonored.
Where the case was filed? So where you want to transfer? Have you not served the notice?
I have found the copy not security service for that does not return to me.
August.
Jalpaiguri area is 50% is Darjeeling district and 50% Jalpaiguri.
Jalpaiguri.
Siliguri, where the bank is, which area under which police station, if it is under Bhaktinagar or NGP, then it has to be filed before the Jalpaiguri. And if the bank or
No, he's not challenging the cause, he's challenging he only wanted to transfer.
What is the reasons for that?
Yes. Why you want to transfer?
They have made a clear opposition. As of the case,
You are the complainant. You are the complainant.
accused party,
Where the accused reside? And where you reside? So why you filed in the Jalpaiguri, Siliguri?
I have filed the Jalpaiguri case. Jalpaiguri.
Where is the complaint case? CGM Jalpaiguri. You have filed the Jalpaiguri. So?
They have made a clear before the transfer the case only on the grounds of jurisdiction.
Ah.
After I am saying to transfer the case.
That is actually sub judice and how can you?
So the matter cannot be discussed. Matter can be transferred.
So that's it. See, you are resident of Jalpaiguri. Where is our check? Not disclosed. Where is the check?
Internal page number 3.
Internal page number?
Page number 30.
30?
The check the State Bank of India, North Medical College, Siliguri branch. This is the check. Right, the matter be transferred to
North Bengal branch, no? That is within Siliguri court, madam. Jurisdiction of Siliguri court.
Check in favor of the complainant by check number State Bank of India, North Bengal Medical College, Siliguri branch. The accused also request the complainant to deposit a check after 2. Okay, no problem. Then the complainant according presents a check to the payment of Bank of Punjab National Bank. You are presented also in the Siliguri. So,
the matter be transferred to Siliguri.
where is the other side? Where is the service? Could not solve.
I was directed to serve the advocate below. That was not possible because the record is lying in.
You are the complainant. You have issued the notice under 138. Notice was served. So sent by speed post. That's where is the return? Show me.
Address is not found.
Address is not found.
Chocolate was there. Come on. Both.
Address cannot be looked.
Which address you have sent? Same address?
Yes.
What is the address in the complaint? Shankar Roy. Shankar Nath Roy. Resident of village Kawakhali. Near out of Delhi, return to address. He cannot be located. What is the stage of the trial? What is the stage of the complaint case?
Stage of the complaint, I have executed all the documents.
Evidence started.
They have not.
Where? Jalpaiguri?
Well, they have not processed the meaning, but I have had all the orders.
Kindly come to page number 20. Kindly page number 19. Page number 19. Exhibited below the document.
And they are residing in Jalpaiguri, Siliguri. Yes.
There, I think I could because they are residing in Siliguri. Rather, Siliguri court would be easier for them. It's up to my lord regarding the transfer matter.
The petitioner has filed the present application. What section you have filed this, revisioner? Why you not filed this application before the session judge? For transfer of the case?
No, districts are different.
Districts are different.
Jalpaiguri district.
No, district to district. District judge can.
No,
that is
within district.
District, yes. Within district, district to district.
Your lordship has application 407. Interstate. 407, your lordship was up.
Yes. The petitioner has filed the present application under section 407 of the Code of Criminal Procedure 1973, corresponding to section 447 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for transfer of CR case number 415 of 2019 under section 438 of the Negotiable Instrument Act 1881, pending before the learned Judicial Magistrate, Third Court, Jalpaiguri, to learned Assistant Chief Judicial Magistrate at Siliguri. Full stop. Now, counsel for the petitioner submit that the petitioner, the opposite party number 1, office party number 2, has issued the check of where is the details? Issued the check of rupees 5 lakh, being check number issued 5 lakh of State Bank of India, North Bengal Medical College Siliguri branch, Darjeeling, in favor of the petitioner. The petitioner has presented the said check before the said bank, but the same was returned to the petitioner with the endorsement, funds insufficient. Full stop. The counsel for the petitioner submit that the petitioner is residing at Jalpaiguri, and accordingly the petitioner has filed the after the dishonor of the check, the petitioner has issued the notice to the opposite party number 2, but in spite of service of notice, the opposite party number 2 failed to pay the check amount, and accordingly the petitioner has filed the case, filed the complaint case before the learned court of which court you have filed? Before the learned court of Additional Chief Judicial Magistrate, before the learned court of Judicial Magistrate, Third Court, Jalpaiguri. Learned counsel for the petitioner submit that the petitioner had inadvertently has filed the said case before the court of Learned Magistrate Third Court Jalpaiguri instead of the appropriate court at Siliguri, as the cause of action has arose at Siliguri. Counsel for the petition submit that the case is at the stage of cross-examination of the complainant and cognizant. He further submit that the opposite party number 1 is also residing as Siliguri, and the bank is also situated at Siliguri, and the witnesses are also of the Siliguri. And as such, if the case is transferred from the London Court of Judicial Magistrate Third Court Jalpaiguri to Siliguri, none of the parties will be prejudiced. Full stop. The petition, so Learned APP in charge is present on behalf of the state. None appears on behalf of the opposite party. The petitioner has filed the affidavit of service wherein it reveals that the notice sent to the opposite party was returned to the petitioner as the opposite party is not available at the address. This court finds that the petitioner has sent the notice to the opposite party at the address which is mentioned in the cause title. Let the affidavit in opposition, let the affidavit be kept in full stop. Considering the above, this court find that the check is issued by the opposite alleged check, the opposite party alleged to have been issued the check. They find that the opposite party number 2 has alleged to have issued the check to the petitioner of State Bank of India, North Bengal Medical College, Siliguri branch, and the check was also dishonored at the Siliguri branch, and the opposite party number 2 is also residing at Siliguri branch. In view of the above, for the interest of justice and for the interest of justice, CR case number 415 of 2019. Within bracket, Pradeep Sarkar versus Shankar Roy, pending before the Learned Judicial Magistrate Third Court Jalpaiguri, is transferred to the Learned Additional Chief Judicial Magistrate Siliguri. Full stop. The Siliguri. Full stop. The Learned Additional Chief Additional Learned Magistrate. The Learned Magistrate Third Court Jalpaiguri is directed to immediately send the record of the above mentioned case to the Learned Court of Additional Chief Judicial Magistrate Siliguri through the district judge. Siliguri district judge is Siliguri. Additional in the Siliguri additional district judge, additional session judge. To क्या बोला? Through the additional district judge Siliguri immediately. Full stop. On receipt of the record,
additional one because he is the political transfer.
Additional one.
He is in charge.
And on receipt of the said record, the additional district judge test 1 at Siliguri immediately forward the case record to the Learned Additional Chief Judicial Magistrate Siliguri, and the Learned Magistrate shall immediately issue the notice to the opposite party if the opposite party is not appearing, and to conclude the trial as early as possible by giving an opportunity of appearing to both the parties. CRR is disposed of. Yes, come tomorrow. Today. Yes, come tomorrow.
But some preference if this.
Are Baba, now we are already reached 55.
Yes.
So it will be within 20 matters.
I'm grateful.
Huh? Tomorrow it is time, and let it be see whatever is needed. Come tomorrow, I will take the matter.